Yes.
Kindly order 41.
Yes.
Okay. We have a lectures kind of matters, one for admission and another one for hearing the lecture.
Admission mentioned. Hearing. No.
My lord, one CAN application I have already mentioned. File has been come, but CAN application could not be found. May I be permitted to put a Xerox copy before your lordship?
We don't understand.
I have mentioned this application. Main file has been come, but CAN application could not be found.
Could not be found.
May I be permitted? This is
No.
my-
When it comes up in the list, we'll you hand this over and give a copy to the other side.
my
তখন লিস্টে দিয়ে দেবেন ক্যান নট হিয়ার বলে দিয়ে দেবেন
May I permit?
No, keep it. Yes.
May I permit to mention one matter? Lordship, with due respect, on 22nd April, your Lordship ordered us to file the application without the certified copy. We filed it, and your Lordship directed us that it will appear in the list. But it's very unfortunate that in the case status, it shows that the matter appeared yesterday, but it was not there in the list. My only humble prayer is kindly include the matter in the list, Lordship.
We did not direct anything. We never direct at the time of granting leave. We don't direct it to appear in the list. We have not directed in a single matter. You are somewhere wrong. We never direct a matter to appear in the list along with granting leave. We must have granted leave. No.
May be permitted to mention a matter before your lordship. This is my CAN application for
Application handover.
my application is pending, but in the meantime, estate officer has passed the final order only to influence my CAN application. That is the
What do you want now?
your lordship.
What is your prayer?
My prayer was to there was an injunction order.
Yes. Now what do you want?
I just want my extension application being done.
Hand over the slip. Yes.
Lordship, item number 112 of today's list. And may I praying that let it be included under the heading application, and application is pending. We have filed one application.
Yes. 112 application heading e diye deben kal.
Today's, your lordship, may I mention, my lord, 123 of today's list, my lord. This is a hearing matter, my lord, but your lordship may possibly will release the matter because
123 of today's list.
yes.
Achha.
Nawal Sultania versus Hemant Kumar Shah.
Achha. So there's a chance of release
For the respondent.
to be mentioned tomorrow?
Yes.
Be mentioned tomorrow. Yes. Yes, please.
My lord, may I mention one matter, my lord? I am led by Mr. Sanjay Bose.
What is your mention?
Recall, my lord, the lordship was already here the matter and admitted, and it is now listed on under the hearing. So there is filing another CAN, my lord. Another CAN. Another.
You're mentioning that CAN?
Yes, my lord.
Mention the item number in today's list also,
Lord,
so that it can appear along with that.
my lord, my lord.
Lordship, may I permitted two matters for admission hearing.
Yes. ভুল হয়েছিল কিছু নাকি মিস হয়ে গেছে আচ্ছা
মিস হয়ে গেছে অনেক থাকে একসঙ্গে তো
হ্যাঁ
কোনোভাবে চোখ যায়
আমারও ইয়েস কলম
My application.
Yes.
This is that matter where the service had been made on the deceased respondent instead of the substituted respondent.
Now what about service? We'll have to
Just come back again.
served on the substituted respondent.
Yes.
What is the fate of the?
Just come back. And my lord, I also have.
What are the endorsement? I mean, what is the left? Then you have to.
And this is on the advocate in the court below. He has endorsed that. Please send to the client.
Because he does not have any.
But he's proceeding with the execution. And this is the address in the decree, my lord. There were advocates who had entered appearance. We served them. They've also returned, saying we don't have instruction.
This is service of the condonation application as well as the stay application.
Yes. Your lordship will find it is recorded that they have entered appearance. It is recorded in the earlier orders, and now they are saying they don't have any instruction. So Vakalatnama filed in the present appeal by the substituted respondents, and now they say they don't have any further instructions. Order.
These are the advocates who are proceeding in the court below also.
No,
So who are they?
they are appearing in the appeal.
Oh, they. Acha.
Kindly
Oh,
see the order dated 3rd January 2020. Appeal was treated as ready towards as regards service, although Section 5 was not allowed. I don't
Acha.
think that would have been the correct recording. 3rd January 2020 order.
Learned counsel appearing for the appellant files an affidavit of service, which it transpires from the envelopes attached to the same that the attempted service could not be effected since the envelopes returned with the endorsement left. So it is pointed out by learned counsel for the appellant that the service has been effected at the address as given in the code below. So next para, learned counsel also hands over a copy of a communication made by the present advocates appearing for the respondents in this court, intimating that they do not have any further instructions to appear on behalf of the respondents and asking the learned advocate for the appellant to directly serve the copies on the respondents. So next para, you're handing up something else also, that envelope.
There was an envelope by whether advocate
An
appearing in
envelope-
the executing court. He has said
An
that he-
envelope is also handed over in court and is kept on record, which indicates that the learned advocate allegedly appearing for the respondents in the execution case, comma, has refused to accept service, saying that the copies be sent to the respondents directly. Push up. In view of the above circumstances, comma, we find that the respondents are deliberately avoiding service and take up the applications for hearing in the absence of the respondents. So can 1 of 2016 is an application for condonation of delay in preferring the appeal. Push up. From the averments made in the application, comma, we find that the appellant was initially not aware of the proceeding or the decree and subsequently, comma, having come to know about the same, comma, preferred the appeal. Full stop. Upon perusal of the averments in the application, we are satisfied that sufficient explanation has been given for the delay in preferring the appeal. So accordingly, can 1 of 2016 bracket old can 3447 of 2016 can 1 appear kuch na?
अच्छा, अच्छा, अच्छा।
Huh?
हाँ, अच्छा, अच्छा।
Can 1 of 2016 bracket old can 3447 of 2016 bracket close is allowed, comma, thereby condoning the delay in preferring FAT 15 of 2016 full stop. There will be no rise to cost. The appeal is deemed to stand registered and admitted. Full stop. Next para. একই order pass করছি রিকল করেছিলাম যেহেতু সার্ভিস হয়নি next para. The application for stay of operation, comma, bearing can 2 of 2016 is now taken up for hearing. Full stop. Since execution has been levied in respect of the impugned award of enhancement of compensation under the Land Acquisition Act, comma, we find that unless a stay of such execution proceedings is granted, comma, the appeal has every possibility of being rendered infructuous before being heard finally. Push up. Accordingly, we grant stay of operation of the impugned award as well as stay of all further proceedings in money execution case number 17 of 2014 pending before the learned additional district judge, third court at Burdwan, district Poschim Bardhaman in LA case number 22 in connection with LA case number 22 of 2007 till disposal of the appeal, comma, subject to the appellant depositing the awarded amount with the learned registrar general of this court within 4 weeks from date. Post up. Next para. In the event the said deposit is not made within the above timeline, comma, the order of stay shall stand automatically vacated without further deference to the court. Post up. The stay order shall operate unconditionally for 4 weeks and thereafter, comma, upon the deposit being made, comma, the same shall continue till disposal of the appeal. Push up. Next para. Upon the deposit as per our above direction being made, comma, the learned registrar general shall invest the said amount in a short-term interest-bearing fixed deposit scheme with any nationalized bank and furnish the details of the same, comma, if so approached by the learned advocates for the parties. Full stop. Next para. The said deposit shall be subject to the outcome of the appeal. Full stop. Next para. The appellant shall deposit the requisites and postal costs for service of notice of appeal on the respondents within a fortnight from date. Stop. The trial court record shall be called for by special messenger at the cost of the appellant, also to be deposited within a fortnight. Full stop. Upon service of notice of arrival of the trial court records on the learned advocate for the appellant, comma, the appellant shall prepare and file the requisite number of paper books within 8 weeks thereafter. Full stop. Liberty to mention the appeal for inclusion in the list as and when the same is ready for hearing.
Obliged.
ওটা দিয়েছিলেন কিন্তু মৃত লোকের উপর সার্ভ করেছিল বলে আবার রিকল করে নিয়েছিল।
Answer the respondent.
Respondent.
This is for enhancement. The application is CAN 4, enhancement of alimony. But I believe, my lord, may I come back on Monday with full instruction, because the matter was once settled by the coordinate bench, my lord, of this honorable court, wherein, my lord, 23 lakh were, my lord, directed to be paid, my lord, as a lump sum, out of which 9 lakh already paid. What is this scenario as on today? Why, my lord, this departure from the earlier, my lord, stand? My lord, may I come back
Have
on
you been
Monday?
served with an affidavit of asset? Further affidavit of asset?
No.
With the NSO? No.
Lord, if at all that would be necessary, my lord, we shall. Lord, may I take instruction and come back by Monday?
Yes, we'll,
Giving notice to Mr. Chatterjee. So, Mr. Chatterjee was there, my lord.
Achha, your copies of paper books could not be served because you could not be contacted. Please ensure that you take the paper books. None appears for the appellant at the appellant stroke petitioner at the time of call. Full stop. On the prayer of learned counsel for the respondent, comma, the matter is adjourned till when? Next week.
May I come back on 5th?
Till
Monday.
May 5, 2025. May 6, 2025.
Lord, 6, my lord, I have some difficulty.
May 5 is a combined list day.
Oh, then, my lord, 7, my lord, your lordship keeps it.
May 7, 2025. Full stop. Next para. The learned advocate and record for the respondent shall contact the department for being served with copies of the paper book in the meantime. Thank you.
My lord, item number 3, I am for the appellant. I am being led by Mr. Joydeep for my lord. Will be kind enough to take this matter on Monday, my lord.
Depends on Mr. Mukherjee. Yes.
I'll tell you, lordship, very short point involved here. My lord, his personal difficulty, I have no problem. My lord, they are the appellants.
Right.
I have a decree. Now, my lord, Green Profits was directed to be paid under the decree. My lord, they were granted a stay, my lord, unconditional stay. And for a period, then, my lord, if they made a deposit, my lord, of 30 lakhs, then, my lord, the stay, my lord, would, my lord, operate. My lord, they failed to, my lord, make payment of that 30 lakhs.
Achha.
Then, my lord, subsequently, they got an extension. And, my lord, they made payment, deposited this 30 lakhs.
Yes.
But, my lord, the stay which they were granted, my lord, has expired, my lord, from, my lord, February 2020, giving, my lord, the benefit of, my lord, the orders of court, my lord, during COVID period, my lord, that's gone in 2022. My lord, nothing's being done. Now, my lord, as per the decree, my lord, another 4 lakhs minimum, my lord, needs to be deposited to cover, my lord, that security. And we've also asked, my lord, in this application, if we could, my lord, take, this is Indian Oil, my lord, 4 kathas of land, my lord, on Free School Street, Park Street crossing, is, my lord, where they are, my lord, sitting. My lord, we are, my lord, saying, my lord, that if they wanted to settle also, my lord, it didn't work out. Now, my lord, the
now that original application for stay is before us, or
my lord, we have
fresh
made an application,
Oh, your
fresh
app-
application,
Achha.
my lord, CAN 5, my lord, for my lord, deposit of a further sum, and if he could withdraw by putting in, my lord, a bank guarantee. That's our application.
My
Let us
may,
pass this direction.
my lord, may I come back?
Very well. Heard learned senior counsel appearing for the respondent. Full stop. However, comma, since an adjournment is sought on behalf of the appellant stroke petitioner, appellant stroke opposite party in the application, comma, let the matter stand adjourned till
My lord, next
Monday.
Monday.
Adjourned till Tuesday because Monday is the combined list.
Combined list.
Yes. Till May 6, 2025.
I am grateful, my lord.
Affidavit of service filed to be kept on.
Oh, my lord, my learned junior is not there on Tuesday. Kindly
Oh,
make it.
yes. So sorry. Returnable data 7th. May 7th. Yes. He told in the last one.
Yes.
Yes. What is can 4 for?
Can 4 is restoration.
Achha. Restoration of can 3.
Yes.
Achha. What is the appeal about?
Appeal about one partition suit was filed.
Right.
And partition suit has been dismissed on the point of only sole point of non-joinder and misjoinder necessary parties. That has been challenged in the appeal.
No,
And
can 5 is an application for restoration.
Can 5 was a application restoration that has been allowed by the Honorable Court yesterday.
Achha. Oh, this was the second.
Yes, sir.
I'm for the respondent.
Yes. Why did you restore? You gave some ground which drew our sympathy.
Yes, my lord, there is an office report, my lord. Kindly see the order, my lord. It's office report.
Why is it was dismissed for default? Even
Yes, we see that.
restoration of service, my application. Yes. Matters should be moved with due diligence.
Legal aid matter.
My lord, since 2016.
Always sympathy and at sympathy. Legal aid with you know how it is conducted. Probably your learned friend has joined later on.
My lord, there is also defect in the cost schedule.
What is the defect?
This defect, my SK, Akhtar Ali and others.
In the order.
So also there is a direction is.
Tolovana has not been put in. You are appealing for all the respondents.
Oh no, 1 to 7.
1 to 7. Then you have to
Sheikh
put in.
Faisal Muhammad and Kulsum Bibi, Procedural is right. Sheikh Faisal Muhammad is the appellant. And Kulsum Bibi and others are the respondents.
Let us see the memorandum. What is that?
And also there is a direction to remove the defects.
Yes, there was a direction to remove the defect.
No, there's a
No,
office
2023.
report that defects were removed.
Yes.
Date of judgment. Plaintiff such and such does not find place. No, it has been removed. There's a further endorsement that it has been removed. So there is no defect now.
Okay.
Can this is
Can
can
5.
4.
This can 5.
Can 4, can 5.
And 5 has been allowed.
Can 5 has been allowed. Can.
Can 5.
Can 4 of 2024 is taken up for hearing. Full the same is an application for restoration of Can 3 of 2020, which was dismissed for default by this court on November 12, 2024. Full next para, learned counsel appearing for the petitioner submits that the petitioner is approaching the court through legal aid and as such was not in a position to properly pursue the matter due to financial restraints. Full next para, learned counsel appearing for the respondents opposes the application and submits that this is the second instance of dismissal for default and as such a strict view ought to be taken by the court. Full stop. However, upon hearing learned counsel for the parties and considering the marginalized circumstances of the petitioner, we are of the opinion that the petitioner is entitled to a lenient approach. Full stop. Accordingly, upon being satisfied with the grounds taken in the application, Can 4 of 2024 is allowed without any allowed on contest without costs, thereby recalling the order dated November 12, 2024 and restoring Can 3 of 2020 to its original file and number. Full stop. Interim order, if any, stands revived as on this date. The appeal is otherwise the office shall furnish a report as to whether the appeal is otherwise ready for hearing.
Can 3 has not been disposed of.
What is Can 3?
Can 3 is for injunction. Milord, what happened? What happened, Milord, during pendency of this appeal, Milord?
This appeal is against what? Dismissal of partition suit.
Partition suit. And Milord, this during pendency of the appeal, they started by construction in the suit property. I filed this application 2020. The previous
have to grant injunction.
My lord, this is a legal sanction, my lord.
One of you argue.
No.
There was an order of injunction.
No, there is no order of injunction. Please don't. Well, I'm submitting.
No.
I filed this application. This application was heard previously by the Honorable Division Bench of Honorable Justice Tapurbodo Chakraborty and Parthasarathi Chatterjee. Honorable Court did not grant me any interim injunction, but kept this.
But in the dismissal order, it was stated interim order. We said if any stands vacated.
Yes.
So there was no interim order.
No interim order.
Then grant the interim order. Don't make construction.
The construction has already been completed long ago.
I don't
We'll
have-
direct to file affidavit in opposition and
Opposition.
direct both parties to maintain status quo in the meantime.
Very true.
Learned, Can 3 of 2020 is an application for injunction. Full stop. The appeal arises out of the dismissal of a suit for partition filed by the plaintiff stroke appellant. Which of next para? It is contended by learned counsel for the appellant that the respondents, particularly the respondent of 5, has been making construction of the suit property, thereby altering the nature and character of the same. Full stop. Next para. Learned counsel appearing for the you are for 1 to 7.
1 to 7.
Learned counsel appearing for respondent was 1 to 7 submits that there was no injunction previously, and as such, the construction which was being made by the respondent of 5 has been completed. Full stop. To bring the proper picture of the factual circumstances of the matter, we direct the respondents to file affidavit in opposition, affidavit within bracket S in opposition to the application within a fortnight from date. Full stop. Replies, if any, shall be filed within a week thereafter. The application shall next be listed on June 10, 2025 for hearing. Full stop. The parties shall maintain status quo with regard to the suit property as on today till disposal of the application.
Great.
God bless you.
Thank you. You are quite senior. You know what to do, but please bring the proper picture of the present status of the property in your opposition, so that we can get a picture, literally a picture.
100%.
Yes.
Not
Appeal dismiss ছিল? Along with can 3 of 2020. বাকি সব ঠিক আছে। Thank you. ভুল হয়ে যেত।
God bless you.
Thank you. আমি তো হ্যাঁ, ও আচ্ছা। আপনি merit চলে গেছেন।
The defendant responded.
Defendant respondent. Who is for the appellant petitioner? So Manoj Rai. We give them one chance. None appears for the appellant stroke petitioner at the time of call, although the respondent is represented by counsel. You are for which of the respondents?
The file
The two respondents or more?
2 million. 622. Hira Mujumdar and Abra Mujumdar. Others not.
No, two series now. No. No. One. There are 4 respondents.
In my copy, my lord, name of Amit and Abir, Amit Mujumdar, Abir Mujumdar have been struck off. The copy which is served upon me. I have a file Bokaratna for my lord Dhira and Abra Mujumdar.
You have instruction to appear for the others also.
No, I have not.
Take instruction to whether you
No, I shall.
although but in the main copy,
Fine.
the numbering to it 1 A B C, that was the initial number, that has the alphabets have been deleted. 1 2 3 4, they have been now numbered as 1 2 3 4, but all 4 are there.
I'll take instruction regarding the other.
Although the respondent numbers who Dhira and Abro,
Dhira and Abra.
respondent numbers 1 and 4 are represented through counsel. Full stop. Next para. Let the matter stand, adjourn for the day. We are doing that only. Take instruction in the meantime if you have instruction to appear for all of them. That will cut short time. What is the defect?
This is substitution application, my lord. There is a delay some days, my lord. Upon the date of the applicant number 1, my lord.
I am praying for not today in
Why?
this matter. I have instructed to do
Oh, my God.
You are ready in the matter.
Oh my.
You are appealing for which of the respondents?
I just asked to take note today in this matter for the respondent.
Yes, what do you say?
Substitution application,
Substitution within time? No.
No, Lordship. There is
Then
a
let
case.
them come. We'll give them one chance. Although the petitioners are represented through counsel, an adjournment is sought on behalf of the respondent. Full stop. Accordingly, let the matter stand adjourned for the day. Adjourned for the day. If on the next date you don't, you take time or don't appear, then we'll pass ex parte order.
And it's-
Lordship, I'm for the appellant, Lordship.
Yes. What is the
So I
application?
filed the CAN 3 application, which is expunge application. I have duly served with them also. During pendency of this appeal, Lordship, the respondent number 1 died. Lordship, the mother.
Yes, we are allowing the expunging application.
Well, other errors are already on record.
Yes. CAN 3 of 2025 is an application for expunging the name of the respondent number 5 and respondent number 1, comma, since deceased. Full stop. It is submitted by learned counsel for the appellant that the heirs and legal representatives of the deceased respondent are already on record. Full stop. As such, comma, CAN 3 of 2025 is allowed, thereby expunging the name of the respondent number 1 from the appeal. Full stop. The learned advocate on record for the appellant shall, comma, during the course of the day, comma, carry out the necessary deletions of the name of the respondent number 1 in the other pending applications and the memorandum of the appeal. Please do that during the course of the day. What are the other applications now? আচ্ছা প্রথম লাইনে একটা করে দিই affidavit of service file to be kept on. What are CAN 1 and CAN 2?
Lordship, the CAN 1
Section 5 and
is
3.
section 5 and CAN 2 is my stay of that. The
Section 5, what is the delay?
Lordship, the delay is 1,000.
Only 1,000.
1465.
1465. As because Lordship.
What does it translate to in years? 4
4 years something.
4 years something. What is the reason?
Approx 4 years. The reason is Lordship.
Cough
I
and
was
cold.
not-
Cough and cold for 4 years.
No, absolutely not. Lordship, I was not residing there and I was somewhere else.
It was an
I
ex
was-
parte degree.
Yes, it's an ex parte degree. I was not residing here. The service has not been summoned. The summons has not been properly served to me, Lordship, because I was not residing there. Soon after I came to know, Lordship, I duly applied the certified copy and filed the appeal before your Lordship. As for the section 96 of the.
Yes, Mr. Bhattacharya.
No, cannot be. Cannot be. Why, my lord? Kindly see the scope of the suit. What happened, my lord? There is a bar under section 97. What they want to do.
97 of?
Civil Procedure Code, my lord, when the preliminary degree is not challenged, my lord, this appeal has been filed from the final degree. And kindly see, my lord, the grounds of appeal and the memorandum and the section 5.
No, if the preliminary degree is not challenged, no appeal can be preferred against the final degree.
No. They say preliminary degree, my lord, was passed ex parte. Therefore, they have two remedies, either Order 9 Rule 13 or challenge from the preliminary degree. Now, my lord, in the meantime, final degree has been my lord, engrossed in stamp paper, executed, and parties have been allotted their share. Now, my lord, they have challenged, my lord, the final degree in this appeal. Now they want to say in the section 5 application, the preliminary degree is bad as I was not given the summons. That cannot be done.
No, that will record that since the appeal itself is against the final degree only.
But kindly see the premise of the appeal is section 5. Kindly see, my lord. Kindly see, my lord, the several, my lord,
No, they say they never appeared in the suit at all. So preliminary degree or final degree, the same thing.
No.
The explanation will be the same. If they did not appear in the suit.
No. Definitely, my lord. Then, my lord, still now they have a remedy against, my lord, the preliminary degree, not a challenge against the final degree and say preliminary degree.
In this appeal, Mr. Bhattacharya, if even our allowing this section 5 or dismissing this would, dismissing obviously would, allowing this section 5 would not affect the nature of their appeal.
But they are.
We'll record your submission, but we'll say that this appeal has been preferred against the final degree only. And
they will not be permitted to say that the preliminary degree was bad because there is no challenge.
This appeal they cannot.
Exactly.
They cannot unless they prefer a separate appeal. With now they have to file a section 5 explaining The entire period.
And they were aware of that.
Yes, because the moment
Now-
they filed this appeal, they from that date till that date,
Yes, Milord,
even after that date, they have to explain.
now, Milord, kindly see, Milord, the section 5 application, Milord.
Yes.
There are certain, Milord, amendments, Milord, which I will show to your lordship.
Yes.
Kindly see, Milord, all on the merits of the Milord, kindly comes to Milord can 1.
You're Mr. Banerjee.
No, Lordship.
You're
Mr.
Mr.
Shaw, Lordship.
Mr. Shaw. Mr. Shaw, take your seat.
Sir, he is-
Let us. Acha, first move your application. What is the cause of the delay? Then we'll hear.
Lordship, this cause of a delay, I have
us
reason
the
out. I have
paragraph.
already reason out, Lordship, in my Can 1 application.
Which
Page
paragraph?
If your
para
Lordship,
6
the
onwards.
Lordship, the page 4, para 5.
Page 4, para 5.
Lordship. Lordship, your petitioner state that the petition appellant, the judgment data number 2, having a
Oh,
different.
the basis of your of the entire application is that you were never served.
Yes,
so how
I
did you
was
come
never
to
served.
know? How did you come to know for the first time? Who was that?
Lordship, in para 14, I have explained. The day when I came to know, Lordship, because all of a sudden I got a phone call from some person, Lordship, that the degree has been passed against me without.
This is a
without-
novel,
Yes.
it's a novel
Lordship,
story.
Lordship, I was not there on that property because
Who
I
called you over the phone? Because we have to look
the
into that also.
neighbor, Lordship, the neighbor of the suit property. They called me
Oh,
that
you are living elsewhere.
yes, I was doing job as an assistant professor before the Jadavpur University. At that point of time, I was annexed the agreement of the leave and license agreement. During the suit, I was somewhere else. And soon after, when I came to know, Lordship, I applied for the certified copy. I came to know that already in the year of Lordship, the 30th of August 2023, I came to know. On 31st of August 2023, I got the certified copy that on 20th of September 2019, behind of my back, without serving a notice of a summon, the expertise degree has been passed against me.
This is the final degree.
This is the final degree. Lordship,
20th of
kindly,
September 2019 is the final degree.
Lordship, kindly see my the Can 2 application, page 51. Can 1 application, page 51, Lordship.
1 or 2?
1. Lordship, section 5. 51.
Yes, final degree.
Lordship, the order in part, this should be same as the same is hereby decreed in final. I got the running page 52 is the final decree, Lordship.
Right.
All these running page. Then I prefer this appeal before your Lordship.
What do you state about the phone call or whatever?
Lordship, the page 14.
Page 14.
Para 14. Para 14.
Para 14 is something else.
Nothing about.
You don't say anything about how you came to know suddenly. That becomes relevant because otherwise knowledge would be attributed to you before that. Because it's a huge delay after all.
Lordship, at least the
No, para 13 you
so
have
far as
stated.
the
Para 13 you have stated from reliable source.
Yes, Lordship. Lordship, this so far as the suit for partition and
Not
injunction.
very convincing. Because your knowledge, source of knowledge becomes important because of the reason, because you say that you never had knowledge.
Lordship, because what happened, Lordship,
So it becomes very vital. It has to, something
your lordship-
credible has to be stated regarding how you came to know. All on a sudden you come to know without from reliable source. We have to look into whether that reliable source could have informed you earlier. Who is that reliable source? It has to be credible to us.
I'm grateful, your Lordship.
There is nothing here.
Lordship, I'm bound by your Lordship. Lordship will kindly see the page 30 of that application. If I would have not received that summon, whether that summon, Lordship, the order 5 rule 20 has been followed. The order 5 rule 17 has been followed.
Cannot go into that question at this stage, at the section 5 stage. We cannot go into that question at the section 5 stage. That would pertain to the merits of your challenge also, maybe.
Yes.
May or may not be. May or may not be. Because Mr. Bhattacharya is right on that. Because if you don't prefer a challenge against the preliminary decree, we could have understood if you preferred a challenge and appeal against the preliminary degree simultaneously with an appeal against the final degree. Then we could have looked into it. But now it hits at the root of the preliminary degree also. In the garb of an appeal against the final degree, we have to proceed on the premise that the preliminary degree has attained finality. If that be so, how can I look behind that? And this, your knowledge for the first time on 30th of August, we are not convinced. If you are made aware by some reliable source, that reliable source could have told you earlier, and you say that first time came to know from reliable source that they have filed a suit for partition along with such and such.
Yes.
It has been renumbered. So if they inform you about the filing of the suit after after 4 years after filing of the preliminary degree, a final decree, they could have done it earlier when this suit was filed. Nothing precious, nothing has been stated in this application. Why should we allow this application? 4.5 years delay, not
Lordship,
so
I
casual.
must be candid, Lordship, on this point. Lordship, if I would, Lordship, I would say that the other day, that the day when the original, the day when the ex parte degree has been passed, I came to know on the very next day. Lordship, I must be candid on this, Lordship. I am submitting before your Lordship is very honestly that on which day I have come to know.
Not so honest. Not so honest. Not you, I mean, your client. Whatever you are speaking about is you are just representing somebody.
Yes.
Reliable source, you came to know the suit. No, we are not convinced. Sorry. Cannot allow this application. Can 1 of 2023 is an application for condonation of delay in preferring the present appeal which has been taken out against the final decree passed in a partition suit. Push up next para, learned counsel for the appellant submits that the appellant, comma, for the first time, comma, learned about the filing of the suit on August 30, 2023, and thereafter, having inquired into the matter and applied for certified copies, comma, upon learning of the suit, comma, obtained the certified copies and at the earliest thereafter has preferred this appeal. Push of learned counsel appearing for the appellant seeks to take the court through the annexures to the present application, thereby indicating that the appropriate provisions of Order 5 of the Code of Civil Procedure were not resorted to prior to taking up the suit for ex parte hearing and passing the impugned decree. First of next para, learned counsel appearing for the which respondent?
Now, both. Mother is
Appearing for the respondents
other two, my lord.
submits that one and there are 3 respondents.
Yes, mother now lordship at expunged.
Right.
The other two.
Learned counsel appearing
Daughter.
for the surviving respondent submits that section 97 of the Code of Civil Procedure prohibits a person from challenging the preliminary decree passed in a partition suit in the event such preliminary decree was not challenged prior to passing of the final decree. So in the present case, comma, no appeal has been preferred against the preliminary decree of the partition suit. Footstep, the present appeal pertains to the final decree. Footstep, it is submitted that, comma, as such, comma, the appellant cannot take the court behind the preliminary decree and reopen the preliminary decree at this belated juncture. Footstep, it is contended that by arguing that the plaintiff, that the defendant stroke appellant was never served with a copy of the summons, comma, the preliminary decree itself is sought to be challenged by the appellant. First up, next para, learned counsel also controverts the averments made in the application for condonation of delay on merits. First up, next para, even without going into the question as to whether the present appeal, comma, in an indirect manner, comma, seeking to challenge the preliminary decree, comma, since it is well settled that as no appeal has been preferred against the preliminary decree, comma, the final decree in a challenge against the final decree, comma, the preliminary decree cannot be reopened, comma. We are not convinced with the explanation given in the application for condonation of delay as to the cause of such delay being bona fide. Full stop. Next para, in paragraph number 13 of the application, comma, the appellant stroke petitioner contends that on August 30, 2023, comma, the appellant stroke petitioner for the first time came to know from the within double inverted his reliable source double inverted close that the plaintiff's respondents have filed a suit for partition. Full stop. Next para. However, comma, firstly, comma, the nature of the reliable source has not been disclosed. Full stop. Secondly, comma, it is unexplained as to why such within double inverted reliable source did not inform about the suit earlier to the plaintiff, to the appellant. Full stop. Next para. Since the explanation given is not that the final decree, since the information pertained to the final decree being passed, but alleges that even the filing of the suit was informed only on August 30, 2023, comma, there is no conceivable reason as to why the reliable source of the plaintiff, of the appellant, could not intimate the appellant about such institution of the suit at an earlier juncture. Full stop. Next para. That apart, comma, the span of delay is considerable and we are not convinced from the meager explanation given in the application as to why the appellant was not diligent enough to prefer the appeal earlier. Full stop. Next para. Taking into consideration the averments in the application as a whole, comma, we find that sufficient explanation for the delay in preferring the appeal has not been made out. Full stop. Accordingly, can 1 of 2023 is dismissed on contest without, however, any orders to cost. Full stop. Consequentially, FMAT 466 of 2023 is dismissed as time barred. Full stop. Can 2 of 2023 is, comma, accordingly, comma, also dismissed. No orders to cost. Sorry. প্রথমে যদি না বলে থেকে অ্যাফিডেভিট স্যাটিসফাইড করে না অর্ডার ফর্মে
বিপ্লব
কি অস্ত্র নিয়ে এসছিস? কোনটা এটা? 22 তারিখের বয়স কে কে? মোবাইল ফাইল করে
Yes. Item number 8, when I'm appealing for the respondent number 2, 4, 5, and 6.
What about 1?
One died, my lord, this legal representative already substituted on the earlier occasion, my lord. There is evidence of service to that effect.
3, my lord, died during the pendency of the suit. They have filed an
So
application.
1 we recorded
No.
something. Mr.
Yes,
Rai,
yes, yes,
1
yes.
we recorded something previous.
অ্যাপিলেন্ট হলো কি করে? অ্যাপিলেন্ট হবে না,
Respondent.
Can 2 was
Can
allowed.
was allowed where, my lord, the respondent 1 was sought to be substituted by their legal heirs.
That has
That
been
has
done.
been allowed. Your lordship was pleased to
Yes.
react accordingly for correction of the memorandum of appeal. That was done, and accordingly service has been effected to the heirs of the another.
Now this is an application for what?
This is for injunction, but my learned friend informed me that this for number 3, no?
He has also died.
Before passage of the degree, during the pendency of the suit.
What was the suit for?
Suit for partition.
Their suit.
No, it's my suit for partition.
You are challenging a preliminary
Degree.
Then this degree would be bad.
The suit was dismissed, my lord.
Defect of parties.
Defect of parties, that is some other reason, but not
But that decree could not be passed.
that degree.
That dismissal could not happen in the name of a dead person.
Because application already, it appears well that an application has already filed that was pending, that was not taken into consideration.
Application for substitution of his heirs.
No, order 1 rule 10 application was filed, but being
Yes.
the heirs of the disease was this one number 3 herein. But that application was not taken into consideration at the time of passing of
Give
the
us a
hearing.
copy of that application if
Yes,
you
my
have.
lord.
Then we'll allow the appeal on that ground only and send it back. Application was pending without hearing. On your submission, we'll do that. No, you are not submitting that. It may be allowed, but we'll record your submission that this application was filed, but this was not disposed of. Without disposing of, it was the suit was dismissed in the name of a deceased person.
I should correct myself. If I don't know whether this is disposed of or not, now only one thing I'll say,
Unless this was not disposed of, how could it be passed in the name of the dead
that
person?
cannot be. That cannot be. 6 or 7 times plaint has been amended. 6 to 7 times. If I'm not-
Maybe.
Well, I'm
If 6 or 7 times people die, what can they do? There cannot be an injunction against that.
many change. Totally, part by part they have added.
That has been allowed.
No,
We cannot reopen that.
last last point, the learned judge has taken, in spite of giving us specific opportunities to the plaintiff, there are defect of parties.
When was the judgment passed? The preliminary.
2023 January.
This is an application of 21.
21, but this application is whether when it was placed or not, I don't have that, because I found it from my record, The bunch of
degree it
papers-
appears, my lord,
bunch of
this
papers,
person's name is there.
So whether this was placed
In the
or not,
degree itself, my lord.
Even if this application was not filed, if it is in the name of a dead person, what happens?
now many persons were left out, the specific point taken by the learned judge, you have not made the parties. If your lordship kindly sees 3 pages of the order, then it will be clear, and nothing else. First time, they have prayed partition.
This person has left heirs.
Yes, yes.
Dismissal. After dismissal, we cannot rectify the defect. If this was during a pendency, in the pendency, if it was against a misappeal, it would percolate down. Post facto, how can we rectify the null decree?
But there are also,
Even if it's a partition suit, we could have been very lenient, added parties, do whatever. If this was a misappeal, it would percolate down. But on the day when the decree was passed, this person was dead. If that be so, that on that date it was a nullity, and it's a partition suit, joint property, everything intertwined rights.
He could have bought because when it is own brother died. Haripada Pal's 4, 5, 6 sons. One of the
partition suit does not abate in that fashion. Particularly if an application was filed, it could not.
But to be very
bound in duty of the court to decide. You take into information.
One thing, may I prefer your lordship?
Information whether this
I'll take instruction whether it is
filed or
at all allowed. Sometimes
might have been dismissed.
Might have been allowed or dismissed, but it does not reflect in the degree itself.
Yes.
So if I can you give me sometimes
at the juncture when the application bearing can 1 of 2023 is sought to be moved, comma, learned counsel appearing for the respondent submits that the respondent number 3 had died prior to the passing of the impugned preliminary decree. Push up, learned counsel also hands over a copy of an application under Order 1 Rule 10 of the Code of Civil Procedure for addition of the heirs and legal representatives of the said deceased respondent, filed in the code below. Pushed up, learned counsel are not properly instructed as to whether the said application was actually moved and stroke or any order was passed thereon, comma, which might have a direct bearing on the question as to whether the decree passed by the learned trial judge, the preliminary decree passed by the learned trial judge was a nullity in the eye of law, comma, being passed in the name of a dead person. Full accordingly, comma, in order to enable learned counsel for the parties to take instructions on such count, comma, the matter is adjourned till May 13, 2025. Full stop, appropriate instructions shall be taken by the learned advocates for the parties in the meantime.
May I get me the
Take
copy of
this
the?
back, but we have recorded that it has been handed over
So I'll supply a photocopy of this.
to this. And affidavit of service file to be kept under.
So for the service.
Photocopy টা উনি করে দিয়ে দেবেন একটা। Do it as early as possible, Mr. Rai.
Yes,
Otherwise,
yes,
they'll
yes, yes, yes.
এটা ঠিক ফাইলে ঢুকিয়ে দেবেন।
ইয়েকে দিবি।
I'm just submitting. I'm taking a photo and this.
Oh, that will be best.
ফটো তুলে এটা দিয়ে দে।
Thank you, Your Lordship. Malad, there's a section 5 application, Malad, delay of 3 days, Your Lordship.
3 days we generally don't condone.
Yes, Your Lordship.
So much of delay.
It was
Yes,
filed.
what is your
Malad,
opposition to the delay? We would
But as
like
for the
some
defense-
person at least to oppose a section 5 application.
My lord, 3 days delay, but, my
But-
lord, kindly take the application, my lord.
Yes.
The reason of the delay, my lord, is stated in paragraph number 4.
miscalculation, let's say.
Miscalculation.
Calculation of the council. My lord, I have just one judgment in 1979.
Side. Very interesting. We are wanting something like this. to happen.
My lord,
It
paragraph,
is getting boring otherwise. Section 5 applications we are allowing rejecting.
my lord, paragraph 6 of my lord, the judgment.
What is the reference of the judgment?
1979, volume 4, SCC, page 365. Volume 4, SCC, page 365. And may I hand over, my
Please hand over because it will take some time to switch on my.
lord, paragraph
It
number
has not
6,
been
my lord,
switched on by
kindly see
mistake
the
today.
paragraph 6.
আচ্ছা, miscalculation. You George. Push it, feels it, but
একদম সে দিতে বললেন আগে ফটোকপি
এটা কি করিয়াছে এখন? কৃষ্ণা সেই এর গেছে হ্যাঁ বড় কোম্পানি করেছিল দুর্বল লোকের গেছে Justice Krishna, the appellant was a company and the respondent was a workman.
Ideology. The mistake on the council, my lord, cannot be
They
taken.
are not a company.
They are not a
Both
company.
of you are Mr. Messrs. Joyswal, so on equal footing.
Kindly take note of that.
The present application is for condonation of delay of about 3 days in preferring the appeal. Full learned counsel for the appellant submits that there was a bona fide miscalculation on the part of the advocate in calculating such delay. Full next para. Learned counsel appearing for the respondent cites Messrs. Concord of India Insurance Company Limited versus Concord CONCORD. Concord of India Insurance Company Limited versus Srimati Nirmala Devi and others. Reported at 1979 4 SCC 365 in support of the proposition that the error of calculation made by counsel cannot be a valid ground for condonation of delay. Which of next para, upon hearing learned counsel for the parties, we find that the premise of the cited judgment was that the learned counsel appearing in the said case for the appellant was an advocate of 34 years standing and could not possibly make the mistake in view of the clear provisions of the subject of appeals existing under the relevant provision therein. Full stop next para, in the said case, it was observed that the mistake of counsel may in certain circumstances be taken into condonation taken into account in condoning delay. Although there is no general proposition that mistake of counsel by itself is always a sufficient ground, push up, the yardstick stipulated in the said judgment is whether the mistake was bona fide or merely a device to cover an ulterior motive. Push up next para. In the present case, comma, we find that no effective purpose or benefit could be derived by the appellant in filing the appeal 3 days late. Full stop. That apart, comma, as opposed to the cited judgment, comma, in the present case, comma, the miscalculation was not the result of wrong application of law, but merely an arithmetical error. Full stop. On a whole, comma, we find from the averments in the application that the mistake was absolutely bona fide and as such, comma, ought to be condoned. Full stop. Accordingly, can 1 of 2024 is allowed on contest, thereby condoning the delay in preferring FAT 271 of 2024 without an full stop. There will be no arrest to cost. Full stop. The appeal is deemed to stand registered and admitted. Yes. Something. What is the other appeal? No other application.
No, not sure.
What is the appeal against?
Appeal against the judgment and decree passed wherein dismissing my suit for eviction of licensee, declarations, and
Suit
for
was also
possession.
dismissed. Counterclaim was also dismissed.
And
We have not
counterclaim of
filed
the
it.
defendant
I
also,
have
Your
not
Lordship.
filed, but willing to file the cross objection.
Cross objection won't do. Counterclaim has been dismissed. It has to be an independent appeal. Cross objection won't do. If you find that arguable, you may argue that also. But counterclaim is a different suit, has the status of a suit. Probably cross objection, we won't advise you on that. Let us just we'll direct paper books and all.
Yes.
You are appearing for only one respondent. In view of the appearance of the respondent in the appeal, comma, service of notice of appeal on the respondent is dispensed with. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant, comma, to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready for hearing. Full stop. Since learned advocate for the respondent submits that the respondent may prefer a cross objection, comma, subject to the maintainability of such cross objection, comma, we hereby record that for such purpose, comma, the date of notice of appeal shall be construed to be this date. So if you choose to ultimately file a cross objection, it has to be within 30 days from today. But take a proper advice, Mr. Dev. Yes.
Obliged, Your Lordship.
And for the appellant,
what is the defect?
Defect.
Let us find out. Some defect is there. Not in form বলছে কি not in এই তো report থেকে লিখবে ও আচ্ছা no hearing is required it's a regular first appeal.
Yes.
এসব লিখেছে no hearing is required in order for 26 সব second judge's copy has not been filed.
Sorry,
that is there.
my lord.
আপনার copy আছে but that is also there.
We have
My learned brother has a copy. You don't know that. The office is, yes, the stamp reporter had gone mad.
By that time, perhaps
That time, I could not. Decree, you have not filed any copy, certified copy of the decree. Probably that is the defect.
Degree, perhaps.
No, there is no copy. Then it's defect. You have to file a copy of the decree. Otherwise,
No.
You filed.
Yes, 197. In this application, it is found, but in the candidly.
This is the memorandum.
In the memorandum, it is not.
Certified copy has to be filed with the memorandum, certified decree. Otherwise, the appeal will remain defective because of the other reasons also, you know, because the calculation, the valuation has to be ascertained from the certified copy and the names of the parties, their capacities. So you have to file we'll direct you to file a certified copy of the decree.
We have.
We'll keep the application. You have the degree.
Do we have the degree in it is in the, it is annexed with the CAN application at page 197. That should have been
CAN 1.
Yes, either CAN 1 or 2, same.
Page numbers are same. Annexion numbers are same.
Last annexation, my lord. So for the application for injunction at page 197.
This is a photocopy.
Photocopy. What is the original?
Let us see the other one. Other application. No, CAN 1 it's a photocopy.
And in
No, it's a photocopy in both.
CAN 2 is also
CAN 2 also photocopy.
photocopy. What is the original?
Since you have obtained the photocopy, you must have the original with you also.
My learned brother saying that it was filed, my lord, it is not
You
found.
can check up whether we have.
Yes, it is not
Apna
found.
copy to nahi. All are photocopies.
Yes. It is not appearing in my copy. So, but the memo is concerned.
Memo, it is not appearing. First of all, that we could rectify. We could direct this to be tagged with that. But please find out if you can locate that certified copy. আপনারটা তো লাস্ট annexure কিন্তু দুটোতেই ডিগ্রি আছে কিন্তু ফটোকপি annexure stamp is there.
Yes. Photocopy. Judgment, not judgment, degree.
Without the degree, the valuation parties' names cannot be.
Sorry, my lord.
No question of sorry. You can check up. We don't want to delay appeals on these frivolous matters, but if the decree is not there, it's not there. You could not find out. We also could not find out. So give it back.
It is not.
It's
there.
our property.
Yes, sir.
Public properties.
It is not there, my lord.
Very well. We will direct you to file copy. How soon can you do that? The certified copy, even if it is lost, only 3-page decree.
Friday.
By Friday will be too early. We'll give you. We'll keep it on 13th of May. 2 weeks.
As well, lord.
We find from the records that no certified copy of the impugned decree has been filed along with the memorandum of appeal. Full stop. The learned advocate for the appellant is required to take steps for furnishing the said certified copy on the returnable date. Full stop. Accordingly, let the application be listed next on May 13, 2025. File it on the next day. We'll tag it along with this and direct the office to file it.
Yes.
Thank you.
Is there any?
No copy of certificate copy. Yes.
Defendant number 1 is the appeal.
Appearing for the first time. Which application? The appeal arises out of what suit?
Suit for declaration of right title interest.
A preliminary partition was.
Partition has been refused.
Partition has been refused, but decree has been declared.
Defendant number 1. Plaintiff suit for partition. That has been refused, but so far declaration that has been granted. But they have.
The injunction was also granted to them. Must have been.
Yes.
Let us just check up because we have to be sure that this injunction does not negate that injunction. No, only title.
Right title interest and possession.
Oh, possession has been declared. Yes, you are right.
But I have annexed the document.
So what sort of injunction you are asking?
Not to disturb my possession.
That, how can we do that?
Because my lord, record of rights is in my name.
No.
And my lord,
the decree stands.
BLRO appeared in the suit. He has produced a report. Report shows that my lord possession is with me.
Mr. Mahato, till we set aside that decree, if you do, that finding that they are in possession and that decree regarding possession is still there. So we cannot reverse that at the interim stage by granting you injunction restraining them from disturbing your possession. It has been held that it is in their possession.
But my lord, what is the basis?
That we can decide in the appeal only.
Yes, that can be. But
that this time we cannot grant injunction.
Since the my lord, the report of the BLRO, my lord says that I am in possession. They are not in possession. They are possession, my lord, in respect of only 25 decimals, not 27 decimals. But not in respect of.
We cannot upset the final decree of the final decree impugned in the appeal at the
But
stage
so
of
for
hearing.
possession, it should be stayed. At least it should be stayed.
No. Injunction, even in appeals against ad interim injunctions, we don't
But
stay.
in the meantime, I may be dispossessed.
We'll direct them to restrain them
Malad,
from.
kindly consider, Malad, they have stated in their plaint that the record of rights is erroneous, but they have not prayed for declaration that the record of rights is erroneous. Secondly, Malad, they have
Serve a
not.
copy, Mr. Mahato will just direct them, restrain them from changing nature and character and transfer lending, which are your other prayers. Position will say that at this stage we are not granting. We will give the reason.
But Malad, kindly consider this. Malad, report of the BLRO says that it is Malad Patta land, their land and my land. Malad, from the records, Malad, the reports, I have annexed it, Malad, at page 13.
How did the trial court proceed with that? Deal with that?
Malad, nothing, no observation.
Then
They have, Malad, stated.
Then we have to go one step further. We have to go into the evidence of the matter at the injunction stage. To see the record of right and say that the decrees were unknown.
Malad, kindly consider their case. Malad, they have stated in the plaint that they have got the settlement of the suit property, that is, Malad, 75 decimals by virtue of a settlement case number 1118081. But my lord, nothing has been discussed in the judgment regarding that settlement case. Whereas, my lord, the report produced by the Blockland Arrangements officer.
Exhibit 1 is the original patta granted in respect of 75 decimal.
The proceeding by which, my lord, that patta was granted, that has not been given.
Definitely not at this stage.
Whereas, my lord, the patta was also granted in my favor, and the case numbers has been given by the Blockland Arrangements officer. The patta records was also produced before the court. My lord, kindly see page 13, serial number 4.
That will decide in the appeal, Mr.
But for the time being, it should be stayed so far possession is concerned. My lord, otherwise, my lord, I may be disposited in the meantime. Declaration of right title, I am not praying for stay, but so for possession.
No, sir. The present appeal arises out of a decree for declaration that the plaintiffs to respondents have right, title, interest and possession over 75 decimals of land in the suit plot. First of next para. The suit was filed also praying for partition, which was not granted. Who's of learned counsel appearing for the defendant number 1 stroke appellant contents that the impugned judgment and decree are perverse, inasmuch as the learned trial judge did not take into consideration the specific recording in the records of right as well as the settlement case records, which clearly indicate that it is the defendant number 1 stroke appellant who is in possession and not the plaintiffs stroke respondents. Full stop next para. However, we find from the impugned judgment that the learned trial judge inter alia considered exhibit 1, which is the original patta granted in favor of one Kedar Pal, as well as the oral evidence of the parties while coming to its conclusions. Full stop next para. Although the defendant number 1 stroke appellant might have made out an arguable case to for hearing of the appeal on merits, we find that it would be prematurely deciding the appeal itself in the event at this stage we come to a contrary finding than that of the learned trial judge in the impugned decree, to the extent that the possession of 75 decimals of land is with the plaintiff's respondents. Full stop. In such event, this court, sitting at the ad interim ex parte injunction stage, would have to enter into and assess the evidence on record and virtually upset the finding of the learned trial judge, thereby pre-deciding the appeal at this premature stage. First up, we are loath to undertake such an exercise at this juncture. However, insofar as the other components of the prayer for injunction made before us is concerned, we find that a strong prima facie case and a case of balance of convenience and inconvenience being in favor of grant of injunction has been made out. Push up next para. Accordingly, the respondents are restrained by an order. Only the plaintiff respondent, Mr. Mahato?
Plaintiff's respondents, 1 to 4.
Very. Restraining, accordingly, we pass pass an order of injunction restraining the plaintiff's stroke respondent was 1 to 4 from changing the nature and character of the suit property and or from transferring, alienating and or encumbering any portion of the suit property in favor of any third party in any manner whatsoever till disposal of the present application. Full stop. We leave it now. We leave the question as to whether the appellant is entitled to grant of injunction to the stage of final hearing of the present application. Full stop. The petitioner shall serve copies of the present application on the plaintiff stroke respondent numbers 1 to 4, indicating that the application shall next be listed for hearing on May 19, 2025. Full stop. Affidavit in opposition, if any, shall be filed by May 8, 2025. Full stop. Reply, if any, shall be filed by the next returnable date. Full stop. An affidavit of service shall be filed to that effect by the appellant on the returnable date. Full stop. Service of copies of the application on the respondent numbers 5 to 18 is dispensed with for the present.
My lord, I appear on behalf of the plaintiff appellant, my lord. My lord, I have been instructed, my senior advocate, Mr. Parthasarathi Bhattacharya will be appearing.
On the last occasion also you played for time, not in this.
No, this is the first time.
You have been instructed to do what?
My lord, my senior will appear in this matter.
What is the defect? Let us
My lord,
out of time is it?
Yes, my lord, there is a delay.
What is the delay? Section 5?
Yes, my lord.
How many days delay?
52 days.
At least we direct, there is no caveat.
No caveat.
We'll direct you to serve copies for that. Mr. Bhattacharya is not necessary. One is order 40 on Rule 27, another section 5.
Yes, my lord. Another is injunction application.
Injunction. Serve copies of all the applications that come.
Lords.
The appellant shall serve copies of Can 1 of 2025, Can 2 of 2025, as well as Can 3 of 2025 on the respondent, indicating that the applications shall be listed next on May 13, 2025 under the same heading. Full stop. An affidavit of service shall be filed by the appellant on the returnable date.
Advocate.
Thank you.
Item number 13.
Yesterday I missed the matter, my lord.
This matter was taken up yesterday, my lord. It
What
was
did you do?
directed to appear in tomorrow, my lord. But
It was actually appear tomorrow?
yes, my lord.
Oh, but আজকে ভুল করে ফেলে এসেছে। We verbally directed. No order was passed.
Order was passed, my lord.
Order was passed.
My lord, the respondent number 2 has died.
Order নেই তো কোনো?
Respondent number 2 has, my lord,
Wait
expired.
a minute. কি অর্ডারটা আলাদা হয়ে গেছে নাকি? It is to appear tomorrow. The matter is wrongly appearing today, although it was directed to appear tomorrow. Push up. Let the matter be listed tomorrow under the same. Mr. Mahato, please come back tomorrow.
Item number 14.
এটা কিন্তু serious mistake আর এটা. Yes.
For the appellant.
I'm opposing that.
Opposing. Yes, obviously. You're for all the respondents? Two respondents. Both.
One have filed Vakaratma, the other I undertake to not file.
By
course of this week, not I'll have to contact not.
What is the application?
An application for injunction, my lord.
Injunction.
One for temporary and
The other for mandatory. Very good. What is the suit for?
suit for, my lord, actually.
This is the misappeal.
Misappeal. No. Yeah, the appeal application was filed for revocation of
Misappeal has been admitted.
What?
The miscellaneous appeal has been admitted.
No.
Miscellaneous appeals are required to be admitted. Why did you mention the application? There has to be an order for Rule 11 hearing.
Well, previously, that my lord, in the court of
Justice Prasad must be. Yes. What did you do there?
Lord, one application was filed by me, by my client, for giving permission to him to proceed with the appeal. That has been done.
Permission has been given.
Yes.
So you have the permission. What do you do with the permission? No.
This
there was an order also.
Formally admitted.
Yes, formal admission order is there. Wait a minute. What is the impugned order?
Well, impugned order, revocation of probate.
So it has to be registered as a first appeal in any event.
First appeal has been first appeal number.
Oh, it's appearing as a first appeal.
No, FMA.
FMA. Will direct the office to declassify.
FMA 345.
We had refused the stay order and granted you leave to file injunction.
Yes,
That's why we had also recorded that the appeal has been preferred against refusal to grant probate.
No, it was revoked. Probate granted. I filed an application under 263 for revocation. That was allowed. With that, they have come.
Achha. The present appeal has been filed against a deemed decree whereby the revocation, the application of the respondents for revocation of a probate granted in favor of the appellant was allowed. Full stop. Accordingly, the appeal ought to be registered as a regular first appeal, comma, being against a deemed decree. Full stop. Hence, the office is directed to reclassify the appeal and allot an FAT number thereto at the earliest. Full stop. In the memo also probably you have to then correct. Let us see. Because otherwise, no admission hearing is necessary. Memoটা কোথায়? ক্যানের ছড়াছড়ি যেতে মেমোটা বার করে দিন তো মেমোরান্ডাম অফ অ্যাপিল
দুজন লোক এসেছে ইনস্ট্রাকশন দেবে কিন্তু উকিল
the learned advocate for the appellant is also granted leave to rectify the caption of the memorandum of appeal accordingly. You have stated memorandum of appeal from original judgment. It should be original decree within bracket deemed or deemed decree. Do it right now. The applications shall next be listed on May 7, 2025.
Just one submission. But what is happening during pendency of this appeal, my lord?
Whatever submission, you first rectify the defect, you carry out the correction in the memorandum, office will do it and immediately office ke পাঠিয়ে দেবেন আমাদের returnable date যাতে চলে আসে. It will appear on 7th, we'll hear you on that.
For the appellant petition, there is a contempt application pending.
Your contempt application? Your for the response.
Lord, kindly comes to the solemn order, Lord, at page 34.
Contempt application, let us first find out the contempt application. Contempt application contempt Thank you. It a contempt? Sorry, page
34.
34.
Lord, order dated 25th of October 2017.
Yes.
Only the ordering portion, Lord. The defendant respondent is restrained from disturbing the possession of the plaintiff appellant in the suit premises and or the right of the plaintiff's ingress and egress through the common passage to and from the suit premises till the disposal of the application. Now, my lord, I am running operating. This is Grand Hotel, my lord. Inside the Grand Hotel, I have a space, tenanted space, from where I operate, my lord, since 1950 for my cater to my clients and also, my lord, to other clients who come to, my lord, the Grand Hotel. Not after this order was
There was
passed.
a renovation of the Grand
Yes,
in
for
other matters
renovation.
also this is coming up.
Absolutely, your lordship recalls, my lord, in the garb of renovation, my lord, they had disconnected my electricity line. So, my lord, I had come up before this honorable court with a
So possession is being disturbed in that manner. That is your request.
Absolutely. My lord, that is the cause for contempt. My lord, after your lordship's intervention, my lord, for 2 days, my lord, my electricity was restored. Again, my lord, the entire thing went out. Although, my lord, the other places in the Grand Hotel, my lord, they are having electricity. In the lobby, my lord, in other places also, they are having their electricity. Might be, my lord, the load, electricity load, my lord, has been reduced. But, my lord, electricity is there. And for operating a shop room, my lord, I don't require, my lord, heavy voltage, my lord, or high voltage.
What is your
operation.
status there? Legal status?
Lord, I say that I am a tenant there,
They say
and
you are
they say I am a licensee.
But no eviction has been filed.
Lord, yes, now they have filed a suit for eviction that is pending.
Achha, this appeal is against what?
This appeal is against my suit for declaration of my tenancy rights.
That was dismissed.
That was dismissed, and it was found that I was a licensee. Against that, the appeal is there.
Yes, what do you say?
So far electricity is concerned, for few days there was no electricity because the entire hotel is now lock and key.
You said that on the last occasion.
Yes. Now this shop is not on the arcade. This shop is inside the hotel, in the lobby. That is the peculiarity of this shop.
But the other position,
The others may be the other footpath, what we call the arcade.
Your lobby is also electrified now.
No, the lobby, once we enter the hotel, and in the left hand side is the entrance to the hotel, and once you enter into the hotel, this shop is still on the left. It's in the lobby.
Around this suit property, there is no electricity.
There is electricity. 1 or 2 bulbs are
Then
there.
why?
Yes, he is having it. There was a disconnection because of the main line. The transformer was changed. We have applied to CAC. Load was reduced. No AC air condition. Nothing. So there was a disconnection, I admit. Thereafter, from 4th of March, it has been restored. 2 points has been given to him, and he's if he doesn't. The difficulty is there can't be any customer today in the shop because everything is closed. This shop has no
business now.
Pardon?
No business. No
No
running.
business. He has no separate entrance. His only entrance through my main gate, which is closed. Only the trucks, bricks, motors are coming in. No customers are coming in. So he has also removed some of his important articles and all. What he's saying, he's not going there to put the lights on. If somebody is going even today, the special officer, Ashok can appoint a special officer to advocate on record.
Very classy way of putting, Lord, things, Lord, when I have committed a contempt.
No, it will
Go and switch on the lights. You can go there and
Yes, Lord, we are
I'll
going
direct
there.
the costs of your visit to be borne by them.
Lord, kindly
by
have
the
a
Grand
look at
Hotel.
these photographs.
Photographs, we
Lord, I
don't
can
understand
supply
anything.
a copy to them
Electricity,
also.
how
It's a copy card.
Lord, to demonstrate that other places of the
So
hotels.
your case has to shock not the conscience but the physique of the judge.
Yes, Lord. That's
Because
what
you are on an electricity matter.
That is exactly what
So
I'm saying.
it's not a shock on the conscience but on the physique of the judge.
Lord, what I'm trying to
You
demonstrate.
don't want to touch this electricity.
What I'm trying to demonstrate with your lordship is the other areas are having electricity. My shop specifically does not have it. Kindly, Lord, comes to.
Right now, we'll send somebody to.
My
Yes.
rights. Yes. But not the joint.
Joint advocates on
Because
record.
there is no restaurant.
Junior most advocates on record
Yes,
from both sides.
Yes, both sides. Yes.
Right now.
Right.
Go there.
We can come back at 2 o'clock.
Your expenses.
It's
On
at
record.
their instance,
No,
Lord, let that be shared, Lord.
365 is no more
Because
opportunity.
today I am before your lordship only because of their
restaurant
instance.
is no
Lord, I
more
did
there,
not
they
disconnect my
Live
electricity.
bear
and
your
come.
own expenses.
They bear
And should bear.
Yes, on record. Advocate.
And they are Lord Oberois. They are shying away from paying.
So what? Oberoi or Rubiroi does not matter to us. It's all the same before a court of law. Oberois are entitled to law also equally.
Yes.
learned counsel for the applicant in the contempt application alleges that in the teeth of the order dated October 25, 2017, one of you go out and instruct your client to do whatever immediately. To take some time first. October 25, 2017, whereby the defendant respondents within bracket alleged contemner was restrained from disturbing the possession of the plaintiff stroke appellant within bracket present petitioner bracket closed in respect of the suit premises and stroke or the right of the plaintiff apostrophe s ingress and egress through the common passage to and from the suit premises till the disposal of the application, comma, the alleged contemner is violating such order by disconnecting the electric supply to the suit premises. Post of next para, learned counsel for the petitioner also seeks to hand over certain photographs indicating that the lounge adjoining the said shop room is at present enjoying electricity. Post of next para, such contentions are controverted by learned senior counsel appearing for by learned senior counsel for the alleged contemner who contends that contrary to the allegation of the petitioner, comma, the petitioner is at present enjoying electricity from 2 points at the suit premises, full stop. It is further submitted that in view of the ongoing renovation of the Grand Hotel, comma, which houses the suit premises in one of its portions, comma, the electricity supply in general to the said premises is said building is being truncated. Full stop. Next para. Moreover, comma, it is alleged that the petitioner is no longer having any business currently, comma, in view of the entrance to the hotel and consequentially to the suit shop room being blocked due to construction work. Full stop. Be that as it may, comma, learned counsel for both sides agreed to appointment of special officers immediately to ascertain as to whether there is existing electricity connection to the suit property. So accordingly, we appoint the learned advocates on record for both sides, comma, respectively. Who is from your side? Give the name.
Lord, Mr. Bhupender Gupta.
Mr. Bhupender Gupta, within bracket, for the petitioner, bracket closed, and Miss Pooja Shah, within bracket, for the alleged contemner, bracket closed, as joint special officers to immediately go and inspect as to whether the suit premises is having any operational electricity connection. Full stop. The matter shall be taken up for hearing tomorrow when it will be listed under the same heading, when the learned special officers shall apprise the court of the current state of affairs. Right now, you don't have to file a report, just verbally apprise. Yes.
Like, they will be able to take photographs if required.
Acha, liberty is given to the learned special officers to take photographs and produce copies of the same tomorrow, comma, if so required.
The difficulty is, my lord, 2 days the electricity is provided immediately, my lord, when the matter
We
is
want
taken
to
up.
see whether operational electricity connection is there.
Yes.
That is to be seen.
Yes.
Not whether now it's the light is on or light is off, obviously not.
Oblige.
Lord, one submission, Lord, item number 14, Lord, as per your lordship's previous direction, I filed today two supplementary affidavits, Lord, and also affidavit service. Lord, kindly, if your lordship kindly mention it in the order, Lord. I have filed
Item
today.
14 ke niye check to mention kore dite affidavits filed today be kept on record. Item 14.
And also supplementary affidavit has been filed, Lord.
How many supplementary affidavits?
Two. For two can separate
Supplementary affidavit filed koise aaj?
supplementary affidavit filed.
Dekhen. The supplementary affidavits and the affidavit of service filed today be kept on record kore. Ekbar check korun je ache ki. Yes, yesterday.
My lord, in view of the last order passed by your lordship yesterday, my lord, so far that appeal is concerned, my lord, the memorandum of appeal is required, my lord, because I shall have to draw my lord's attention to certain observation of the land. Actually, my lord, that is the main appeal. The partial decree for eviction was passed.
But the rest remains the same. Everything will get here.
Here, but my lord, observation are there. So far the partial decree is concerned.
No, but that has merged into this now. After the rectification, we cannot look into that.
That is obvious, my lord.
We'll look into only this, Mr. Raut. Because this is the last judgment and decree which
No doubt, my lord, no doubt. But after passing of the subsequent modified decree.
We cannot look into the previous one. We won't look into the previous one. Those things must be repeated here also. We cannot look into observations of the previous one which has been rectified, and now this is the existing decree now.
So far rectification is only description of the suit property, nothing else. So far the observation and finding of the first appellate court.
No, the judgment remains the same.
No, my lord. No.
Judgment has been changed.
My lord, so far this subsequent judgment under review.
Yes.
My lord, that is only with regard
under review.
My lord. By exercising the review jurisdiction, the earlier judgment was modified.
Oh, acha.
That was modified. Well, subsequently, it is my mistake. Yesterday, I should have pointed out that one. Well, that file is required.
No, very well. Which is that file? Which appeal?
What appeal?
41.
Well, 59 of SA 59 of 2023. Yesterday it was appearing in my lord's.
Yes, file. That's why we have written the file. Appeal has been disposed of, but a file has been written.
Only your lordship kindly give me liberty to draw my lord's attention.
Very well, whatever. Yes.
My lord.
What is the matter?
My lord, so far the modified decree is concerned. My lord, by exercising the review jurisdiction, the description of the suit property, in respect of which the decree was passed by the first appellate court, that has been modified. My lord. And so far the, my lord, the passing of the decree for partial eviction, your lordship will find from the appellate decree at the
So
first.
modified to what extent? What has been modified?
Only, my lord, instead of the previously described suit property, in the first.
Oh, that was the wrong description, right? The rest remains the same. So what are your two grounds?
My first ground is
yes.
So far the passing of the decree, partial decree for eviction is concerned. First of all, the first appellate court did not consider the provision of subsection 3 of section 6 of the West Bengal Premises Tenants Act. And secondly, my lord. And secondly, my lord, so far the observation of the your lordship, yesterday I submitted before your lordship, their suit on the ground of regional department failed. First appellate court passed a decree only for partial eviction. So far the requirement of the plaintiff is concerned, it was observed by the first appellate court that no further accommodation is required. Only for the purpose of carrying on the business of the son of the plaintiff. Although, my lord, not a scrap of paper was produced before the landed court below to show that the son is a businessman. My lord, without considering that aspect in the matter, a portion of my suit property, my lord, suit property is a single unit, one room only. My lord, I have been carrying on of my business of my lord, the goldsmith. The first front portion of that room is being used for showroom. Middle portion is being used for my office. And while inner back portion is being used for manufacturing small jewelry. Well, this is the entire suit property. Well, your lordship will find from the modified the decree of the first appellate court. Well, the 50% of my shop that has been taken away. It cannot, without complying with the provision of subsection 3 of section 6. And that about my lord, the additional sorts, the alternative additional accommodation is there, as it appears from the commissioner's report. And it has been reflected in the judgment also. That in the alternative additional, the alternative accommodation is there for the purpose of carrying a suitable business.
Where is that? How far is that away from the?
Within 100 square, 100 meters. from the suit property. Two big rooms are situated lying in the ground floor of the
That is an ancestral property.
ancestral property.
He is a co-sharer with another brother.
Two brothers. 3-story building. And ground floor, two rooms are lying vacant. These are not.
There is judgment of the Supreme Court, Mr. Raut. Co-ownership cannot be treated to be a.
No, they are in possession of that room.
To be an alternative.
The decree holder.
What is that?
Commissioner's report.
No, if Mr.
Yes,
Raut, let him produce. You don't have a right of hearing otherwise, but we can ask you if he does not.
My commissioner's report has been reflected in the judgment itself. In the judgment itself. As it appears from the commissioner's report, two big rooms.
Achha, let us see the commissioner's report.
Exhibit 22A.
Yes.
If you have another copy, Mr. Raut, give us another
Yes,
copy so that
yes.
both of us can. Where is the alternative accommodation bill dealt with?
My lord, I am coming to that. Point number B1 आ गया अच्छा.
Nandaram Sen.
My lord, 5/2 Nandaram Sen Street.
Page number 12.
Page number 12. On the ground floor. In front of the entrance, in a conspicuous place.
It's already being used, both of the rooms.
By the plenty. By the plenty. When the for the dwelling purpose, the suit property has been fully allotted to the he get the decree. In the suit property, there is ample. And even then, during the pendency of this appeal, the appellate number 1 also died. Family member, the size of the family, wife, married son, and a minor daughter. Enough accommodation is there in the suit.
Wife?
Wife, under the appellant, under the plaintiffs are two, husband and wife. Husband died during the pendency of this appeal.
Their bedroom requirement remains the same.
One widow and married son and their only daughter.
Married son has no children.
Only daughter.
Married son.
Son's daughter.
Their daughter.
Yes.
What is the age of the daughter at that point? 8.
Teenage daughter.
Teenage.
Sufficient rooms are there.
How many rooms are in their occupation there?
7 rooms. And in their ancestral house, 50% of the total building, 3-story building. So far the business, we are concerned with the business of the sons of the appellant. Sufficient space is there in their ancestral property.
Does it open up on the main road?
Yes, my lord. You also kindly place there.
Room in front of the entrance gate.
Yes. Very much convenient.
On the
That was
western
not
side
taken
of entrance passage.
And my lord, so far the partial eviction is concerned, I am going to be evicted.
How did the appellate court deal with this? Let us see.
Nothing. You also kindly come to that one earlier.
Regarding the alternative accommodation for
Yes, my lord, I am coming to that.
Married daughters are also there.
Marriage daughter there.
One room has to be given to them also.
That has been given. That has been given. And my lord, so far that additional accommodation is concerned, there is no discussion, nothing of this sort. Straightway, the learned first appellate court came to the conclusion that if a portion of the suit property is given to them, then their purpose will be served. Only on that basis, without fixing the fair rent, without ascertaining as to whether the tenant is agreeable or not, nothing. The entire observation starts from page 10 of that earlier appeal.
Para 6 code says the accommodation at paternal house is admittedly not sufficient to accommodate. Oh, you say that. So the accommodation, this is sufficient. For accommodation, they have got 7 rooms here. Paternal house not sufficient to accommodate entire family. সব রুমের জন্য তো সেটারই করলাম আর পার্সিয়াল এক্সটেনশন দিলে ওই যে স্কিমটা বলবো সামনে একটা শোরুম তৈরি করে যদি কোয়েশ্চনটা দিয়েছে মর্দান সেন্ট্রামটা যদি দিয়ে দেয় সামনের দিকটাই দিয়ে দিল মাঝখানে আর পেছন থাকবে তাহলে ওখানে কি বিজনেসটা ঝাড় হয়ে যাবে 3-6 কি বলছে দেখছি দেখতে হচ্ছে আগেকার যেটা দিয়েছিল
First of all, the consent of the tenant is a must. And secondly, if it is a partial decree is passed, then in that event, it is the duty of that court to assess the fair rate. That has not been done.
But that does not go in your favor. If you agreed, if you don't agree, then the entire room has to be given to them.
Alternative accommodation is there.
That is another argument. But your partial eviction argument, if 6-3 option was given to you, you say that you are not, even today you cannot agree to that. If we give you that option, if you say we are not agreeable, which you are saying that would not serve my purpose. If you are not agreeable, that law is not that eviction won't be given, then the entire room would be given.
I know.
That does not help you much.
What your lordship kindly consider, if the 50% of a single room is taken away, then what remains thereafter?
Then the entire room can be given to them.
Well, without taking
the law is that
then
without taking your consent, whether you are agreeable to partial eviction, Mr. Rao. If the tenant is not agreeable to partial eviction, you are saying that consent has not been taken. Now, before this court, before us, you were saying that you don't have consent because that will truncate the property. If you are not agreeable, law is not that eviction won't be granted. Then the law is that the entire room then would be given. If you are not agreeable to partition. Partial partition ground, 6-3 notice is not helpful to you. It would be a good point for the landlord if it was landlord's appeal.
So what the fixation of fair rent is concerned, that has not been done. How much?
So then we can direct that to be done. We dispose of the appeal and direct a trial remand and here and now.
No, only your
There is-
lordship. That's true. Your lordship only direct the learned. First appellate court consider the alternative accommodation. Whether that
That's
is
a different argument.
reasonable, suitable or not. 2 rooms, big rooms are there, my lord. Within walking distance. An unjust eviction is not at all desirable at the whims of the unscrupulous landlord.
Ms. Mukherjee, we will admit the appeal on additional on that additional requirement in the other property. We are not hearing you on that. You don't have a right of hearing. Would you please take instruction whether you are agreeable to the us disposing of the second appeal on your consent at the order 41 stage and remanding the matter on the other issues? Will maintain the findings of the trial court. Only the trial court has to consider whether that additional accommodation in the other house, yes, non-the whether for consideration whether that can satisfy the requirement. If you don't, we are admitting the appeal right now.
Any right of audience here?
No, you don't have a right. Then we are admitting them.
Lordship, one.
The present second appeal shall be heard
I will take instruction.
on the following substantial questions of law.
Lordship, one point. The
One,
original tenant has
you don't have a right of hearing this.
2004, whether the
Ms. Mukherjee, you don't have a right of hearing.
Lordship, 5 years has expired. They don't have any right of appeal, Lordship.
You are making out a new ground. Please take your seat. It's not there in the trial court judgment or the appeal court. The present second appeal will be heard on the following substantial questions of law. One, whether the learned judge of the first appellate court committed a perversity in not taking into consideration the 2 rooms available to the plaintiff landlord in the paternal premises of the original plaintiff number 1 at 5/2 Nandoram Sen Street, despite the commissioner's report having depicted that the said 2 rooms are situated on the ground floor of the said property, which is situated within close proximity of the suit premises and might suffice to meet the business requirements of the son of the plaintiff. Only this question. The other question we are not satisfied. 6.3 we are not taking. And only this question. Next para. Yes, stay application is there. Oh,
so, my lord, so far second question is concerned only one thing.
Achha, very well. The other.
But in case of partial eviction, I have to pay the rent.
Very well.
That has to be.
The questions. Second question. Whether the learned first appellate court substantially erred in law in not taking the consent of the defendant stroke appellant under section 6 within bracket 3 of the West Bengal Premises Tenancy Act 1997 and stroke or in not assessing the reduced rent despite having granted partial eviction in respect of of a portion of the suit premises. This much. Yes, stay application is there. They have levied execution.
My lord, yes.
We'll keep the question of occupation charges open.
Ready.
Yes. Since the second appeal has been admitted, we are of the opinion that a strong prima facie case for grant of stay has been made out. Whosoever accordingly, the execution has been levied.
Yes, my lord. Proceedings.
Yes.
Evidence is going on.
We grant we grant stay of all further proceedings in ejectment execution case number 12 of 2021 pending before the learned judge, third bench, small causes court at Calcutta till disposal of the present application. The respondents shall file written affidavit in opposition. Respondents shall file affidavit in opposition to the application, disclosing particulars of the ingredients for fixation of occupation charges, comma, if any, comma, within a fortnight, Ms. Mukherjee, within a fortnight from date, full stop. Reply, if any, shall be filed within a week thereafter, full stop. It is made clear that the question of imposition of occupation charges, comma, and if so, the quantum thereof, comma, as condition for the grant of stay, comma, is kept open for being decided at the final hearing of the present application. Full stop. Liberty to the parties to mention the application for hearing before the appropriate learned single judge, then having determination as and when the timeline for filing of affidavits is over.
Deeply.
Next. একটা লাইন প্রথমেই করে দিও, the report of the advocate commissioner handed over by learned counsel for the respondents today be kept on record.
I am for the appellant, my lord.
Yes.
There is a suit for partition, my lord, filed by the elder son of the deceased, Tasiruddin. My lord, only he is a plaintiff one from elder son. Then defendant number one is next son, my lord, and defendant number two is wife, mother of the plaintiff.
You said a partition suit?
Yes, partition suit, preliminary degree against that. And my lord,
so the trial court, what did the trial court do? Dismiss the suit?
No. Trial court allowed the suit.
Affirmation.
Not allowed the suit, but said that they
granted
preliminary degree, saying that there is a second wife.
Second wife of?
Tasiruddin Oijan, who died.
So Afjuddin is plaintiff is claiming as a son of Tasiruddin.
Afjuddin is one of the
all of you are heirs of Tasiruddin.
No, all of no, it's not that. The plaintiff, elder son, then defendant number was the second son, then defendant number two is wife, widow, and then 3 to 7 is Maladi daughters.
You are the added defendant. Who are
added defendant because Malad the second wife, which was not mentioned in the plaint. Second, the DW2 said that he is the second wife. He is my stepmother. So why you have excluded him?
You are the added defendant. You were added on your.
No, yes, added defendant.
You were added on your own application for addition.
No, Malad. As for that, they have to file the.
So they admitted second wife.
And what happened, Malad? I have purchased the property from the defendant. Yeah, defendant number 9 was subsequently added second wife. Second wife.
So what was done? You were not allotted any share.
No, that in trial court allotted share to the second wife, but appeal court has been that rejected. Only said that the first wife will get it. That is my lord.
What is the reasoning of the appeal court? Let us see the judgment.
My lord. There's a evidence that the wife there's a party maintenance case before the TA against the Tasiruddin and the Parul Bea.
Let's see that finding of the appeal court.
Finding of the appeal
judgment.
My lord, Justice kindly come to
last page 2 of the appeal court.
Yes. That is my lord.
Page 2 of the appeal court judgment.
Yes, my lord. DW2, my lord. DW2 is the advocate. He said that I have done the. Yeah, DW1 is the defendant number 1, Sean. And other sisters also supported.
What is Exhibit J? Original list Talika of Mahar. How does it have a material bearing here?
Some portions of the property, my lord, recorded in the name of the Parul Bea, that is the second wife. That is my lord. He said the record is there in her favor. And the plaintiff did not deny. Plaintiff did not deny that.
Please place the relevant portion, page 2, the
My lord.
decision with reasons.
Appeal court judgments, my lord.
Appeal court, what is the wrong committed by the appeal court? It drew adverse inference against you because Parulba herself was not cited as witness.
Witness, that is.
She was the best evidence. That is one of the grounds. Again, court has disbelieved this exhibit J, which was apparently exhibit J was the proof of the second marriage. What is this original list? Talika of Mahar? Mahar regarding whom?
Mahar to Parul Deva.
Parul.
Acha.
So but that was an exhibit J was a Xerox copy of the original. Appeal court says that it does not qualify even as secondary evidence. Yes, secondary evidence section 65 conditions are not fulfilled. It is stated. Was that document exhibited by with objection or without objection?
And there's no whisper. Rather,
no question of whisper. We are asking you whether that document went without. You are to get ready on that because it's your second appeal.
That is not a said, he has not denied. The plaintiff has not denied. Categorically denied that there is no.
His non-denial also will not make it a valid admissible evidence.
My lord.
He has not denied that you are the second wife.
Yes.
Has he admitted that you are the second wife?
Not admitted, but not said. May I read that portion, my lord? In trial court judgments, my lord. This is in trial court judgment, my lord. Whatever the first wife will get 2 annas. If he said 2 annas. If second wife is then she will get.
Where is the trial court judgment?
Trial court judgment first judgment, my lord, that is.
Who is the present appellant?
The appellant is subsequent purchaser from the Paul Bra.
The present second appeal will be heard on the following substantial questions of law. 1. Whether the learned first appellate court substantially erred in law. Please. Substantially erred in law in reversing the judgment of the learned trial judge, comma, thereby substituting his own views merely because another view was possible, comma, which is contrary to the established principles of law. Second ground, Roman ground. Second, whether the learned first appellate court reversed the finding of the learned trial judge that Parul Bewa was the second wife of Tasiruddin merely on the premise that exhibit J, comma, which was a photocopy, comma, was inadmissible in evidence, comma, without adverting to the extensive findings of the learned trial judge regarding the full sisters of the sole plaintiff and defendant number 1 being defendant numbers 4 and 7 having admitted in their written statement as to Parul Bewa being the second wife of Tasiruddin, as well as the observation of the learned trial judge that PW1, in course of his examination, did not outright deny that Parul was the second wife of Tasiruddin. Full stop. Next para. But this, yes, what you are appearing for whom? You are appearing for whom?
I am appearing for the, my lord, I am appearing for the respondent number 17.
Very well. We can dispense with service on you, but you don't have a right of hearing in order for Rule 11.
There is a stay
My lord,
application.
The application stay of what? The decree.
Yes, my lord. Preliminary decree.
We'll pass the usual. The final degree proceedings will continue, but no final degree. Can 2 of 2018 within bracket old can 8500 of 2018 is taken up for hearing. Full stop. Heard learned counsel for the appellant as well as learned counsel for the respondent number 17, Mr. Karim.
Lordship.
As well as
17.
Learned counsel for the respondent number 17. Full stop. Next para. Since the second appeal has been admitted on substantial questions of law, we find sufficient prima facie case having been made out for hearing the second appeal on merits. Full stop. Next para. There shall be stay. The learned trial judge shall continue with the final degree proceedings. Semicolon. However, the trial court shall not draw up any final decree without the prior leave of this court till disposal of the application. Full stop. The petitioner shall serve copies of the stay application on respondent numbers 1 to 16 and 18 to 34, indicating that the application shall next be listed before the appropriate learned single bench having determination to take up such matters, subject to being mentioned by the parties for inclusion in the list before the said bench. Full stop. An affidavit of service shall be filed on the returnable date before the learned single judge taking up the stay application. Stay application. Good. Good. Next. Thank you.
Lordship.
Thanks. Next. কোথায় আটকালো? রিটার্নেবল আমাদের কাছে হবে না, ইচ্ছে করে দিই না। সেকেন্ড জাজ এবার সিঙ্গেল জাজে হবে। অ্যাডমিশনটা এখানে, তারপর ওরা মেনশন করলে তো।
Your Lordship, in item number 18, I am being led by Mr. Choyan Gupta. He was present in your court, Your Lordship. He is arguing a matter in court number 6. I am praying for a very short pass over, Your Lordship.
He has a right of hearing only if you move the application.
Yes, I have to.
If we, obviously, yes. So whatever defect was there has been cured. There was some defect, Mr. Medora. We will
Yes.
just check up.
There's some noting perhaps in the cause list with regard to court fees possibly.
The copy of decree on appeal bears wrong date. Oh no, this has to be sent down to the court will. 133 days delay. Section 5 has been.
We have filed it yesterday, my lord.
So that has come. Is it before us?
Possibly not. It was filed yesterday, my lord, that I'm aware of.
Then unless that is.
I agree. My
give
lord.
a copy to them also.
This is my vakalat.
File it in the department.
Okay.
Learned counsel appearing for the appellant submits that an application for condonation of delay in preferring the appeal has been filed yesterday. Full stop. Learned counsel is requested to furnish the number of the same. Full stop. Let such application be listed along with the appeal under the same heading on May 6, 2025. Full stop. Did you direct service copy? A copy of the application for coordination of delay be served on the learned advocate appearing for the respondent in the meantime.
Most
Only the
grateful.
section 5 now because we have not yet admitted.
Yes. Grateful.
The application, please ask your learned junior to write on a slip of paper.
I'll have it handed over to your lordship's officers. I'm great.
My lord, I appear for the appellates.
Yes, Mr.
My lord, pursuant to your lordship's earlier direction, we have, my lord, served the copy of the CAN application, memo of appeal, and two, my lord. What happened, my lord? The respondent number 5 has died.
Oh.
And that about, my lord, probably by the order dated 26th March, the lordship was pleased to direct the department to pass this record to the learned trial court for correction.
So 26 March is not our order. 26 March is the
my lord,
office noting. Yes, office report.
Office notice or bench order?
Oh, acha. No. Superintendent SR section. Stamp reporters.
So, my lord, there is a direction.
Learned I am requested to take steps. Name of appellant number 7 in the decree.
That is to be column. That is a mistake, my lord.
So that you have to rectify.
Yes. And deficit court fee has been, my lord, put in.
Deficit court fee
Of 20 rupees. The stamp reporter's report, my lord.
Yes. There are several defects. What has not been done by you? Proper court fees, you have said it has been put in.
Yes, my lord.
So revised report is required for that.
Yes, my lord. I have already put in. That is the, my lord, receipt also.
No, you keep it with you. You are not disbelieving. We'll just check up whether the revised report is there. We'll ask for a revised report, Mr.
Yes.
You do whatever you have to do in the meantime, apart from the certified copy being, if it has been to be sent down, then it's different. Otherwise, there are 6 defects. Please check up and then rectify.
My lord, only my lord, I have single submission.
Yes.
My lord, there are 2 suits and 1 appeal. In 1986, my lord, the suit has been filed by us. In that case, my lord, degree has been passed in favor of us. Now, second suit we have filed because the schedule of...
We have not yet admitted the appeal, Mr. Dev.
My lord, then, my lord, the execution...
Leave is granted to the learned advocate for the appellants to remove the defects as pointed out by the stamp reporter section. Vide report dated March 26, 2025, within a week from date. Full stop. The appeal will be listed under the same heading on May 7, 2025.
And we require to file substitution application for the death of respondent number 5, my lord.
Then we cannot take it up. Then.
Yes.
Acha, shall next be listed যেটা বললাম ওটা কেটে দিন. The appeal shall next be listed under the same heading ওটা কেটে দিন. আরেকটা লাইন অ্যাড করে দিন. Let the matter go out of the list with liberty to the appellant to mention before the defects are cured. If you have to file a substitution application, if it is beyond time, then go before the single judge and come.
Only problem is this, my lord, we are suffering.
No, they are not, sir. Appeal is pending against the previous suit, my lord.
Filed the execution case.
You have not yet admitted the appeal. We don't have jurisdiction to look into the stay. If you so insist, we can grant a stay even before admitting the appeal. So that you have a cause of action for. Because right now, you are eager to argue before us. We appreciate that. And we want people to argue before us. So give you that opportunity, we can grant a limited stay and so that you can come back with the affidavit and argue on the admissibility of the appeal. Not yet admitted appeal, second appeal, not yet admitted. They have nothing. Proceed with your whatever. So they have nothing, know the law. Yes. Language process. None appears for the parties at the time of call. So we find from the records that on April 23, 2025, the matter was adjourned on the prayer of the appellant, as a last chance to the appellant to move the matter. The same is adjourned for the day. What happened to your hand?
It's a fracture. I fell down. Ulna bone of the right eye.
Oh, painful.
Complete fracture.
Please take care. Take your seat. Yes. Call.
21, my lord, landed senior counsel Mr. Probal Mukherjee is appearing for the appellant petitioner.
Yes.
Due to some personal difficulties, my lord, he did not come, my lord.
Why didn't you tell your learned friend he's sitting there from so long?
My lord,
Could have just informed him.
I did not know who was appearing, my lord. Personally, I do not know, my lord.
I get your point. So what do you do? Mr. Probal Mukherjee has not come to court.
No, he had not come to court today, my lord. Father's illness.
Father's illness?
Father's illness.
Monday, your lordship.
You know his father better than us. So therefore, you cannot oppose.
Monday, your lordship.
Monday?
Monday.
Uh,
Grateful.
An adjournment
Let
is.
it retain its position.
It will automatically. The order of attendance list is limited. An adjournment is sought on behalf of the appellants. Full stop. Let the matter stand adjourned till May. We'll keep it on Tuesday. Monday is a combined list day. Till May 6, 2025.
Grateful.
Thank you. ওনাদের নামগুলো রেখে দুপক্ষে ওটা ছেড়ে দিন নামটা
partition. No, it only লিখছি. My lord.
Not called yet.
Oh, sorry, my.
Yes, 22, yes.
For the item number 22,
Mr.
my
Mukherjee is
lord.
appearing in this matter also?
No. Mr. Senior Advocate Mr. Sudeep Sarkar.
Is it now Mr. Sudeep Sarkar?
Yes, he has not come to the.
You hope
court.
his father is all right?
No, his father is.
Father is all right.
It's okay.
Why didn't he come?
Due to some personal reasons, sir, he has not come today.
How personal? How far is it personal?
That I don't know.
You can't share.
No, my lord. He just called
You
me.
start the matter.
No, I don't have any brief. So.
Very well. On the prayer of the appellant?
Not this week, my lord.
On the prayer of the appellant, the matter is adjourned for the week.
But he may be directed to correct the.
And shall next be listed on next be listed in the monthly list of May 2025. Full stop. In the meantime, the learned advocate on record for the appellant shall take steps to rectify the defects as pointed out by the stamp reporter.
Obliged, my lord.
Please tell the advocate on record so that the defects are cured. Thank you.
23, my lord, in this matter, my lord, I am appearing for the appellant.
Yes.
So there is, at the time of filing of this application, my lord, there is no caveat. Subsequently, notice was served, my lord. So I can move the order 41 if it.
Defect number 2 persists, non-filing of certified copy of decree of the first appellate court.
Here. Number of the filing.
Then it has to be in our records. You're appealing for only appellant number 3 or all the appellants?
All the appellants. All the appellants. So.
Have you checked up appellant number 3, Mr. Rai?
Ganesh Kumar Saw.
It no longer works now. The name does not work anymore. Yes, you have to file the certified copy of the decree. Not there. Let us check up, double check. Suit, everything is there. It's not there.
Yes.
We don't find it at least. No. You file the certified copy of the, because it's the appellate court's decree.
Yes.
You have to file it.
Appeal court degree.
Have you got a copy of that? We hope he's not showing the trial court's degree. Do it, we'll give you a fortnight's time, come back on, say, 13th of May. It transfers from the report of the stamp reporter section that the certified copy of the impugned decree of the first appellate court
Photocopy is there, my lord.
has not been filed. We cannot take it. First appellate court has not been filed.
Yes,
Next para,
this is the first
accordingly,
appellate court degree.
certified copy without certified copy.
That is why I don't know original file.
বললাম
করেছি?
না last কি ছিল accordingly বললাম. Accordingly, the appellant shall file the certified copy of the decree of the first appellate court within May 6, 2025. Full stop. The office shall furnish a further report in that regard before the next returnable date, full stop. The matter shall next be listed on May 13, 2025. We have given you till Tuesday to file it so that the office has some time to give the report. And please pursue with the office when you file it.
May it please your lordship, my lord.
Yes, Mr. Yes.
I have served a copy, my lord, and this was the last order which your lordship passed, your lordship. Direction to serve can 1 and can 2
Right.
along with the memo.
Mr. Mitra, please file the affidavit of service. Ask it.
Yes, I'll file the affidavit of service. Let's get first things first. My lord. Affidavit of service.
Yes.
Lord, what happened in this matter, my lord, there was a suit for eviction.
Right.
By the landlord. There was an agreement with the tenant. Suit for eviction was dismissed. Perhaps they said that the landlord was not the landlord.
So, Mitra, there's a section 5 application.
Yes, there's section 5. Section 14.
Oh, that.
I had gone before the civil revisional court, and civil revisional court said there's an appeal. You better go to the appeal court. Justice Shampa Sarkar, my lord. This is order 43. And then, my lord, dismissal of appeal for appellant's default.
You're appealing for the other side. What is the delay, Mr. Mitra, in the
Lord,
period of pendency?
there are two versions of the delay, my lord. Kindly see. One, the judge says, if your lordship has a look at the order of the fast track court, 5th court of Barasat, kindly, my lord, look at page 68. Application has been made referred by the special officer of the appellant company appointed by the Honorable High Court at Calcutta.
68 of Can 1?
Of Can 1, yes, my lord.
No, this is, you have preferred this appeal against what sort of a injunction or what?
My lord, there was a section 5 along with order 41, rule 19. Readmission of appeal dismissed for default.
Against that?
Against that. And the dismissed section 5 saying that because the special officer, my lord, came to know, after she came to know, she wrote to the advocate, give me the papers. He didn't give the papers, he gave the name of the suit. This is a suit, it's been dismissed. So, and I don't have to pay rent. So he said, well, have you got a section 17 application? Because this was 99. 97 Act came in 2001. 99 under the old Act 56, which is like section 7 under the new Act 17, parameter, more or less.
Yes.
So, my lord, no section 17, nothing. And my lord, he is enjoying the premises without payment of any rent. And can you have a look at the agreement? Rental agreement is there. Special officer is appointed by Justice Banerjee, my lord. Can you have a look? Special officer is appointed, Mrs. Ranjana Guha, appointed special officer to collect the rent. And then she writes, she visited the premises and she wrote, maybe slightly later on she wrote, but my lord, the agreement is there. Tenancy agreement is there. Can you have a look at the tenancy agreement, Annexure B? Page 21. And see the rent, my lord, 8,520 square feet, 25 paisa per square feet. And my lord, now he sublet it also. This company, my lord, is a family company, my lord, because of the trouble between the shareholders, special officer was appointed.
In the trial court also, in the trial court, the order 41 rule 19 was accompanied by section 5. There, you are taking this section 5.
No, in the appeal court.
In the appeal court, sorry. In the appeal court, there was a section 5
yes,
along with that order 41 rule 19. There also you had committed a delay, and here also you have made a delay.
No, here I have gone
habitually.
No, I don't habitually. Here no delay. Civil revision. Judge said, because I said
it is not a bona fide error, Mr. Mitra.
No, but I said, there's a jurisdictional error, an error of jurisdiction. Maybe it's blurred now. Because kindly see the order. And if your lordship sees the order, the judge doesn't know how many days delay. First, he says, kindly see page 68. Therefore, the special officers gain the requisite knowledge about the dismissal of the appeal, but thereafter also the instant case, miscase was filed on so and so. After another 9 months, this is the ground. 9 months.
This is the impugned order. We can look into this only once we allow you Can 1.
Yes, because that is dismissing my section 5. Dismissing my section 5 before the
No, but here also you have
to kindly see page 67.
67, yes.
Yes. The record is taken up for order of the application of section 5.
No, no, this is the order impugned in your present miscellaneous appeal. You are reading the order now.
Yes.
The order you are reading now, that is the impugned order in the present misappeal.
In this appeal, yes.
But you have to cross the hurdle of section 14 first, as you say, can 1.
Yes. Section 14, my lord,
Let us see Justice Shorka's order.
Kindly see the last annexure.
How long was it pending? What is the delay in preferring this appeal before us?
My lord, according to me, my lord, if from the certified copy, there is no, what is the delay? Knowledge of 24th November 2017. Order received on 13 June. Default.
Knowledge means your appeal, your revision.
Yes. Now, can you have a look? Order impugned is an appealable order. Miss case so and so is the application under 41 Rule 19. Railway section 151 the code as said, along with rejected by the learned additional district judge for first track, fifth court. It should be fast track, not first track. Fast track, fifth court, Barasat. The appealable and so the disposal of is not maintainable. Liberty to take back the certified copy of the impugned order upon furnishing of photocopy thereof. Petitioner liberty to approach the appropriate court in accordance with law. Contention, Mr. Mitro, learned senior advocate. The limitation was over. Is not required to be adjudicated in this proceeding as recourse could be taken to other provisions of law. So I made this section 14. All I'm asking for, let my appeal be heard on merits.
You are appealing for the opposite party.
No. Then it was changed because they gone on wrongly. Can you see? Matter was mentioned for correction.
Thank God. Otherwise,
no. No, I don't do such things.
Nobody does such things unless. Mr. Mitro, but why should we constitute this to be a bona fide error? Because a person of your stature was leading the petitioner. We have to. We cannot attribute ignorance of law to you.
Your Lordship, because
definitely not. We won't believe you even if you say that.
No, Your Lordship is very kind that way. Kindly see this.
No, we won't believe that because this is a palpably appealable order under Order 43.
No, I'll tell Your Lordship why. Because I thought that once saying 1,000 some days delay and then saying 90 days delay was an error of jurisdiction. A lot of orders which are passed by the lower courts are errors of jurisdiction, not jurisdictional errors, but errors of jurisdiction. If Your Lordship takes that.
Section 115, there is a clear bar.
115?
Section 115, because this was of a nature of order which, if decided in your favor, would have finally decided the proceeding.
No. It will just say that you on merits.
So therefore, 227, you filed at 227.
Yes.
All right.
Just on merits. That's all.
And you filed this revisional application within the time limit for preferring an appeal.
Yes. But then the time which was taken.
No, that time taken we understand. That we will consider.
Yes, that is there.
Was it filed in time? I mean.
Yes, that revisional application was filed in time.
Do you agree to that? Or you will oppose that also? Because
order is.
No, we are asking you a simple question. Whether the revisional application was filed within the limitation period for preferring an appeal. If you don't know, say no.
My lord, no copy has been, my lord.
Very well. Mr. Mitro, please show us the copy of the. Just have you averred in your application? Because that has to be averred. In the first place, if it was time barred, then we also have to consider that period. It is not covered by section 14 alone then. If the revisional application was itself filed beyond the limitation period. Because the impugned order was.
Page 71, my lord. Impugned. My lord.
Please take your seat. Please take your seat. That is not the impugned.
May I just. Your Lordship looks at para 23, page 10 of my Can 1. What happened? The managing director was the only director. He was looking after the affairs. He died. After that, no one was there to prosecute the appeal. And in nobody's case, the appeal was dismissed during his tenure. And what interest will the special officer have, my lord? Special officer is just collecting rents. She saw that some rents were due. So she asked the person and he said that the suit has been filed. And he filed it himself. In 1999 when he was alive. He died in 2011.
Your suit for eviction was dismissed.
Yes.
Your suit for eviction was dismissed. You preferred an appeal. That appeal was dismissed at the Order 41 stage.
For default.
For default, which is why this Order 41 Rule 19, this entire thing came up.
This rigmarole came up. Yes.
And there was a delay of about 2,000 or 1,000.
No. Then we come to see first. She said 90 days.
Anyway, we will look into that later.
9 months.
But that impugned order, the trial court's order, That was passed on 16th of May 2023, right?
Yes.
And Justice Sarkar's order was passed when? 16th of April 2024. So we don't know when this revisional application was filed. We only have to be satisfied, Mr. Mitra, that the revisional application was filed within the limitation period. I mean, within 90 days.
Filed, my lord.
6, 7, 8. Within say,
After I received
14th of August. Do you have a copy of that revisional application?
revisional application, my lord, I don't have a copy, my lord.
Your
lordship can, because I had told the judge, put me on terms. And
not that. Section 14 will definitely apply.
Yes.
We'll consider applying that. But in the first place, you had to file this revisional application within the limitation period for filing an appeal. Because otherwise, that period has to be explained also.
I've tried to explain.
Suppose the revisional application was filed later, after the limitation period.
Maybe, my lord, slightly. Kindly see para 23.
Let us see that, para 23, yes.
High Court had directed the special officer that you do summary proceedings for eviction of those tenants or not, because the company had stopped, my lord, only rental income was coming. So she was taking the rental income and disbursing and paying the salary of the workers and their bonus and other things. Your lordship will see the orders passed by the High Court.
That is different on a different context.
That was in 397 proceedings between the shareholders.
Right.
See, kindly see para 23 and 24, my lord.
It was a special officer's appeal.
Yes. She filed.
So, but
it is noted in the judgment. And then she said that special officer should give evidence in section 5. Kindly see this.
If it was a special officer's appeal.
Not appeal, my lord, what is that? Order 41, Rule 19.
Your appeal special officer filed this application. Because you were under the aegis of the special officer.
Yes, yes. Special officer could only do it.
She was representing it.
Yes. She was collecting the rent and then all decisions for eviction. So she filed it. She was prosecuting the appeal in the absence of the managing director.
No, when did you file the divisional application? We want to know that only.
The application has been preferred by the special officer of the appellant company.
Not this. This is the explanation for the original date.
You will also get the dates there.
227 years.
Dates will be there. I'm not disputing any of the dates.
In para 28, Mr. Mitra, you say that in November 2023, you assailed the impugned order dated May 16, 2023.
Yes.
So May 90 days means June, July, May, June, July, August.
Yes.
So you are already delayed by a month. But since you are under the impression that it's 227, therefore strictly not applicable there.
Strictly not applicable. Equitable, as long as the chancellor's foot.
Please take your seat, Mr. Mitra. We will hear him on the section 5. Yes, what do you say regarding this section 14 being applicable? Because 227, the jurisdiction is rather blanket and the bar of section 115 is not there, that if there is an appeal, no revision will lie. 227, it's mixed. I mean, jurisdictional errors, certain cases courts interfere despite a bar. So why do you say this delay is not bona fide? Because the revisional application was preferred under 227. 1 month after 90 days. But since it was not an appeal nor a section 115, limitation is not strictly applicable, as you know. One has to just explain. So they filed a 227 within a month, and that 227 was dismissed on 16th of April 2024. Within a month, they filed this application, must have been drafted after that and all. This appeal. So why shouldn't we condone this under section 14? We are condoning the delay and then taking up the application and the appeal for admission. The Can 1 of 2024 is an application invoking section 14 of the Limitation Act 1963, comma, read with section 5 of the Limitation Act. Full stop, next para. The present appeal has been preferred against an order whereby an application under section 5 accompanying an application under Order 41, Rule 19 of the Code of Civil Procedure was dismissed by the First Appellate Court. Full stop, next para. Being so advised, comma, the appellant took out an application under Article 227 of the Constitution of India on the premise that there was jurisdictional error which vitiated the order impugned in the said revisional application. First of next para, the said revision was preferred, comma, as per the amendments made in the present application, comma, sometime in the month of November 2023, whereas the order assailed thereby was passed on May 16, 2023. Full stop. Hence, comma, the application under Article 227 of the Constitution was filed within a reasonable period. Full stop. Next para. Since Article 227 is a constitutional relief and the rigors of the Limitation Act are not strictly applicable, comma, we deem the period taken in filing the said revisional application to be reasonable and as such not requiring any separate application explaining the delay. For sub next para, what happened next is that the application under Article 227 came up for hearing before a learned single judge of this court, and the said bench, comma, vide order dated April 16, 2024, passed in the revisional application within bracket CO 4190 of 2023, bracket closed, comma, disposed of the revisional application as not maintainable in view of availability of an alternative remedy by way of an appeal under Order 43, Rule 1 within bracket small t of the Code of Civil Procedure. Full stop. Upon such disposal of the revisional application, comma, within a month thereafter, about a month thereafter, comma, the present appeal has been preferred, comma, upon being drafted and settled by counsel. Full stop. Next para, learned senior counsel appearing for the petitioner submits that since there was a scope of argument on jurisdictional error and alternative remedy is not an absolute bar to a revisional application under Article 227 of the Constitution, comma, the filing of the said application instead of an appeal was a bona fide error, and as such, comma, the provisions of Section 14 of the Limitation Act are attracted. Full stop. Learned counsel for the respondent opposes such contentions. Full stop. However, comma, upon hearing learned counsel for the parties and in the circumstances as narrated above, comma, we are of the opinion that there was sufficient scope of a bona fide error on the part of the appellant in preferring a challenge under Article 227 of the Constitution of India, comma, particularly since the same is a constitutional remedy unbridled by statutory restrictions, and the appellant might have, comma, in its perception, comma, an idea that a jurisdictional error had been committed by the first appellate court. Full stop. In such view of the matter, comma, we are of the view that Section 14, comma, read with Section 5 of the Limitation Act ought to be invoked in the present case. Full stop. Accordingly, can 1 of 2024 is allowed, comma, allowed on contest, comma, thereby condoning the delay in preferring FMAT 199 of 2024. Full stop. The since arguable questions have been made out in the appeal, comma, FMAT 199 of 2024 shall be heard on the grounds as taken in the memorandum of appeal. Full stop. Accordingly, the said appeal is hereby admitted. Full stop. We'll take up the injunction or stay application. Some application is there.
I'm just page 22. Kindly see, my lord.
Yes, sir. Mithra will just immediately after the recess, we'll take up this
Yes,
stay application. We'll continue with this order. Order
no, stay application as such, my lord. It's an application that my.
Acha, let us, yes.
It's not a stay, my lord, because she has dismissed it.
No scope of any stay.
I just want it to be heard on merits. That's all.
So we'll pass, since they're already appearing, you're appearing for all the respondent.
Only one respondent, tenants.
So we'll dispose of, can you prepare paper books within a limited period on these papers? These papers are sufficient.
These are sufficient, my lord. Got everything.
What do you say?
These are sufficient.
We'll dispense with the trial court records.
Yes, yes.
Order 41 Rule 19 along with Section 5. So
Entire document is not here, my lord.
Entire everything is here, my lord. This is If one wants to be nitpicking attitude, my lord,
No,
then
no, Mr. Mitru, we have to, you have to, we'll direct you to prepare paper books, incorporating all relevant papers. If you miss out something, we'll give them the liberty to file a supplementary appeal. and
kindly say,
incorporate
my lord, if anything is missed out here, we will prepare a supplementary because everything is here.
Document missed out of my
it. Just point out to your learned senior friend.
my lord.
Yes.
Or his
Can you point
junior.
out what is missed out?
Let us do that exercise
Not
between
the
yourselves.
judgment decree, my lord,
Acha,
of the trial court, my
It
lord.
is not a judge, it is an order.
Can
It's not an appeal from a decree, it's an order.
No, my lord, dismissal order, my lord. The decree, my lord.
Section 5 along with order 41 rule 19 has been dismissed.
Yes.
My lord. The
So if
trial
we
courts-
allow this appeal,
My
then the order 41 rule 19 would be allowed
Yes.
and the appeal will be revived.
Yes, that's all.
We do not touch the trial court's order.
No, no, no.
It is also, my lord, necessary, my lord. My lord, the trial court's view.
Trial
of
court's
this-
judgments is there.
Not my lord. No.
Furnish the judgment if you have a copy. Photocopies will be required. We don't think trial court judgment is required here.
No, no, no. Why
How is it relevant even?
That is the appeal court will decide that.
Even if they win this appeal finally, then what we do is relegate it, the appeal to be heard on merits.
Yes.
We are not touching the merits of the appeal even.
Yes.
Let alone the trial court's judgment. We are not touching it. We are only considering section 5 and order 41 rule 19.
Yeah.
What they have to annex is section 5, order 41 rule 19 and any opposition if any filed there too. Those have to be annexed. Can 2 of 2024 is taken up for hearing. First up, although the same has been couched as an application for stay, learned senior counsel appearing for the appellant rightly points out that in view of the impugned order having virtually dismissed an appeal, there is little or no scope of stay. First up, learned senior counsel seeks an expeditious hearing of the appeal. First up, in view of the short conspectus of the appeal, we dispense with calling for the trial court records for the present. First up, next para, since the respondent is represented through its learned advocate, service of notice of the appeal on the respondent is also dispensed with. First up, next para, the appellant shall prepare and file the requisite number of paper books incorporating all relevant papers within how much time? 4 weeks? Within 4 weeks
Give me
from
6 weeks.
within 6 weeks from date. And serve advance copies thereof on the learned advocate for the respondent. First up, in the event the respondent is of the opinion that certain other documents are required to be incorporated therein, the respondent will be at liberty to file a supplementary paper book upon service of advance copy thereof on the learned advocate for the appellant at the time of hearing of the appeal. First up, upon such paper books being filed, liberty to the parties to mention the appeal for inclusion in the list for final hearing. Thank you.
May I permit?
Affidavit satisfactory.
At note 25, I'm paying for not today. Appellant is there, Lordship. 25.
Next matter, 25 to call Kurun. Yes, what do you say?
Only praying for not today, Lordship.
You are for the respondent.
Lordship. Section 5 is there, Lordship.
Acha, on the prayer of the respondent, let the matter stand adjourned for the day.
Yes, my lord, learned advocate Pompa Didhabol appearing on the petitioner, my lord, she has not come today, my lord. I'm praying for my not this week, my.
On the prayer of the appellant, the matter is adjourned till May 5, 2025.
For the petitioner, my lord.
Yes.
My lord, can it be taken up tomorrow, my lord?
Why?
The difficulty is what I have heard that there's a resolution from 2 p.m.
No official communication. No unofficial communication also.
It's a communication which I have heard. There's a meeting was held, my lord. Mr. Banerjee, Somnath Banerjee experts.
Yeah, no, that we know, Mr. Banerjee expert. That is
There's
some
a
days back.
resolution from the bar that we know quote from.
Why didn't you take it earlier and inform us?
No, I had heard after the meeting.
You missed the part. What are the applications?
My lord, there are 3 applications.
There was
my
a direction for service of notice.
No,
Applied for the first time. Then let us take it up for the first time. Why appropriate orders?
My lord, appropriate orders, this is an FMAT against the order of injunction. Injunction application, injunction order was modified. If my lord takes up my CAN 4, the order, impugned order is there. The impugned order states, if my lord, there was an injunction application. In spite of that, they have started the construction which is affecting my property. If my lord,
You are the plaintiff.
I am the plaintiff in the suit. Trial court.
Suit is for declaration of your title.
Suit is for permanent injunction.
Only for permanent injunction. Restraining them from doing what?
Doing the construction. They are the during the
construction on their property.
Their property. They have purchased. There was a trust deed. Trust deed says that only the male lines can inherit the property. The last male lines, male descendants, male descendants of the trustee would inherit the property. The male descendant expired. Thereafter, all of a sudden the female lines entered into the property and sold the property to the third party. These the parties are the first appeal is pending before this court.
First appeal against what?
First appeal against that order.
What order?
The title suit for declaration that the suit for declaration that only the male lines in the property has the right over the property, entire property.
That was dismissed.
That was dismissed by the trial court and appeal is pending before this honorable.
You are a party there.
Yeah, I am the.
You are the male line.
I am the male line. In the meantime, the two females, the respondent numbers. So respondent numbers is 3 and 4 had transferred the.
Only 3 is male and female.
3 is male and this
is
4,
female and the performer.
4 is the defendant and she is the son. She is the son. 4 is the son of Nihar Kumar Bormon, my lord, grandson, daughter's son.
This is in respect of the same property.
Same property.
Same property.
Same property.
You ask for injunction so that they cannot
make the respondent number 1 and 2 cannot make the construction.
Respondent number 1 and 2 are made.
They are purchasers. During the pendency of the suit, they have purchased the property
from the females.
Females. There's undivided share.
So why are these applications for appropriate order?
The last application was since after the appeal was registered before this court, the FMAT, there was an application for injunction. Hearing was not. They started the construction. That is in also derogation of the order of the trial court.
Yes, we find CAN 3 and 4 both are for appropriate order. Why appropriate order? That is our question.
3.
You are not
3 and 4. 3 is for substitution, my lord. 3 is for substitution. CAN 3. The defendant number, the respondent number, the pro forma respondent number 6.
All applications you caption as appropriate orders.
But now 3 and 4.
4 is an injunction application. Here, the caption is appropriate order. Why?
No, there's another injunction application is there, my lord. CAN 2. CAN 1 is for condonation of delay.
1 is
for condonation of delay. CAN 1 is for condonation of.
You serve copy of all the applications that come back. The appellant shall serve copies of all the applications and the memorandum of appeal on the respondents, indicating that the matter shall be listed under the same heading on May 13, 2025, when an affidavit of service to that effect shall be filed by the appellant.
I am the appellant.
Yes.
This instant appeal has been prepared against the order dated 24/7/2024, passed by the civil judge, Sri Division, Ulubria Court. But that civil, my lord, the suit value is, my lord, 60,100. Therefore, my lord, this
Goes
application
before
will
the
be
decision. Very good.
My lord, kindly give liberty to take back the certified.
Yes,
copy
yes,
and
we'll
the
do it. We'll do it. Do it.
condemnation of delay.
The condemnation application is also there.
No, my lord, there is a stay application, my lord.
Acha. At the outset, comma, learned counsel appearing for the appellants fairly submits that appellant fairly submits that the appeal is not maintainable before this court due to lack of pecuniary jurisdiction. Full stop. Next para, we find from the valuation statement in the plaint as well as the other relevant papers that such submission is justified. Full stop. Accordingly, FMET number 325 of 2024, along with the connected application, that is CAN 1 of 2024, are dismissed as not maintainable due to lack of pecuniary jurisdiction, with liberty to the appellant to prefer an appeal before the appropriate court having pecuniary jurisdiction. Full stop. We further clarify that we have not gone into the merits of the matter at all. Full stop. The learned advocate on record for the appellant is granted liberty to take back the certified copy of the impugned order upon furnishing a photocopy of the same for the records.
I am for the appellant. Last occasion, my lord directing me to serve the copy of the application.
Yes,
Section
service.
5. Yes. My lord, what happened, my lord? This is a probate proceeding.
Yes.
This is dismissed for default. Against the miss case is also rejected. Against that, I have filed this application. But my lord, I have seen.
Miss case means?
Miss case. Order 9
So
rule
default, order 9 rule line also dismissed. Great. Why dismissed? There was a delay in filing order 9 rule line. How much?
Which section? Before that, my lord, my lord, probate proceeding was filed on the basis of a Nirupan Patra, my lord. I think
so. Deed of settlement.
Deed of settlement. My lord, there is no aberrament.
Withdraw the entire thing.
No, there is no aberrament of the ingredients of will, my lord. I have read out entirely, my lord.
So
and
then
in the
if you
meantime,
don't want to press this appeal, we will say that.
In the meantime, my lord, partition suit is pending. 1/3 each, my lord, first appeal is pending before the Honorable High Court.
First, the partition to you yourself filed?
No, other two sisters.
They filed partition suit on the basis of that Nirupan Patra?
No.
Your defense is that Nirupan Patra?
Yes.
So you appeared there and said that it's a Nirupan Patra?
My lord, it has been in the evidence, it has come out that it is a Nirupan Patra, my lord.
So should we dismiss the appeal saying that you don't want to proceed?
My lord, I want to, my lord.
We'll give the reasons also.
Yes, my lord.
On
the basis of, my lord, kindly see the
we'll say that although
application,
we'll narrate the facts, we'll say that this arises from dismissal of an order 9 rule 9.
Yes.
In connection with the dismissal for ex parte dismissal for rather dismissal for default of a probate proceeding in connection with a purported will. So however, you will say that it's a Nirupan Patra, so therefore you don't want to press this appeal.
My lord, don't want, not my lord, kindly dismiss that because
you want to not press this appeal.
I do not want to, my lord.
You don't
on the basis of, my lord,
say you don't want to press this appeal. We say you want to not press this appeal.
My lord, on merit, my lord, kindly dismiss.
Make it positive.
Because my lord, kindly come to page 18 of the injunction application.
Merits, can we go into that merits in section 5 read with?
No.
So order 9 rule line on the ground of
section
along
5.
with section 5.
Section 5.
So you cannot press the appeal. We may say this that this
on the basis
you will have the liberty to rely on the document by treating the same to be a Nirupan Patra means deed of settlement.
Deed of settlement.
We'll say that.
Yeah.
We'll dismiss the appeal. Not press will not say. Then what will say? We have to say. Otherwise, how can we? Otherwise, you can continue to go on spending time and money on this appeal. If you don't not press, can we go into that question here?
Then my lord, make it not today only. Make it not
Not
today.
today and not placed are mutually contradictory. Tomorrow also the same thing will happen.
My lord,
How will it improve?
with the I asked to client, my lord, only on that, nothing more.
Very well. Affidavit of service filed to be kept on record. Learned counsel for the appellant seeks a day apostrophe accommodation, which will accordingly let the matter stand adjourned for the day. None appears for the parties. কিছু আগের order আছে আমাদের None appears for the parties at the time of call. Let the matter stand adjourned for the day.
My lord, I am appearing for the appellants. This is an appeal from the order of the City Civil Court. Final judgment.
Section 5 is there. This is
Section
appearing
5
for the
is, there is a confusion regarding the time of period of
Period of
limitation. Because under the City Civil Codes, Section 8 says the limitation is for 30 days. And under the Section 5 of the Limitation Act, the limitation is for 90 days. Though there is a delay for only 7 days. We take
treating
opinion.
it to be 30 days, it's 7 days delay.
Yeah.
Or taking it to be 90
from 30 days, it is 7 days delay.
But 90 days should apply.
Under the Limitation Act, it is 90 days. But under the City Civil Code,
The
Section
challenge
8.
is preferred against what? No, the challenge is against what?
From
what sort of a degree?
Well, my suit has been dismissed on contest. Sued by the
Why
tenant.
FMT then? FMT? Yes, suit is dismissed on contest. Why FMT?
First miscellaneous appeal.
Wrongly classified.
Yes. FAT. First
In the memo, you should have written memorandum of appeal from original decree.
Yes,
That is missing. Anyway, the department should have been more cautious. The first let us direct it to be classified properly. Otherwise, whatever order we pass will subsequently change. We find from the impugned decree that the present challenge has been preferred from a decree passed in a suit. So accordingly, the appeal should have been classified as a regular first appeal. So the department is accordingly directed to reclassify the appeal as a first appeal, as a regular first appeal, and allot an FAT number thereto. Full stop. Next para. The learned advocate on record for the appellant is granted liberty to carry out the necessary correction in the necessary correction in the caption of the appeal by introducing the expression within double inverted memorandum of appeal from original decree during the course of the day. You make that correction during the course of the day. The necessary reclassification shall be done by the office within a week from date. Full stop. The matter be listed. Then it cannot be FMAT. There is an application.
Yes, ma'am.
Matter be listed under the heading application on May 13, 2025. It office পাঠিয়ে দিয়ে correction request. উনি correctionটা করে দেবেন। Please carry out
within the day.
Yes.
Your Lordship will be pleased to make it not today if Mr. Shomo Munjal is leading me in this matter. And as the Lordship is
On the prayer of the appellant, let the matter stand adjourned for the day.
Lordship, I beg to appear on behalf of the appellants. There was a caveat we have served. May I file the affidavit of services, Your Lordship?
What is the affidavit of service? You are filing it as. What is the appeal against?
Your Lordship, I am aggrieved by ad interim prayer of ex parte injunction, which was passed by the learned district judge in a suit which was instituted regarding affairs of a society. That is the preliminary point which I will take before your lordship, that the learned district judge lacks the inherent jurisdiction to.
Why?
Led by Mr. Basu.
Which Mr. Basu?
Saptanshu Basu.
So what? So what? The facts of the case do not change. It's a suit under what provision?
Yes, it's a suit. It's a suit where they have challenged, the plaintiffs have challenged their termination, and they are deriving their right to office.
It's not
under,
a suit under section 92.
No, it's a suit under section. It is not a section 25 suit under the Societies Registration Act, West Bengal Societies Registration Act, 1961. Your lordship.
That is the plaint.
Yes. May I show your lordship the plaint? Your lordship will get the plaint from page 40 of my state petition.
Right.
Yes. Your lordship would kindly take straight away the prayers, page 47.
It's filed as a regular suit.
Yes, but the learned district judge is not a section 9 court. My argument would be before your lordship. I'll show from the statute, because the statute only mentions court in only section 25, and section 25 deals with a dissolution of a society. The prayers are not for a dissolution of a society. They have challenged their termination. That I will show from the prayers in their plaint.
Shows the relevant provision?
Yes, your lordship would kindly take West Bengal Societies Registration Act 1960.
You don't have it. Ache?
একটা copy আছে।
Note করেন দুটো আছে।
Which section?
Your lordship would kindly take section 25. The caption of the section is dissolution by court. The court may, on the application of the registrar or on the application of not less than 1/10 of the members, make an order for the dissolution of a society in the following cases. A. If there is a contravention by the society of the provisions of
this is not that sort of.
Yes. Now kindly sees the definition of the court, your lordship. Kindly takes section section 2A, the interpretation clause.
Probably they were more under the.
Even your lordship will see.
It's for charitable purpose they have pleaded.
Yes, but
it's a public charitable trust.
Yes.
Yes,
but registered under the West Bengal Societies Registration Act.
So even if it's registered under the Societies Registration Act, if it's a trust, it did not, I mean, it may, why not invoke section 92 of the Code of Civil Procedure? Have you got a copy of the code?
Without interrupting my learned friend, my lord, section 92 application was filed and leave was granted, my lord, by order number 1.
Order number 1 is annexed somewhere.
No. We have only annexed
this
order
starts from order number 2.
Because only the injunction petition came, that too without the annexures, and the plaint also came without the annexures. And in the midst of this appeal, a police application has also been filed. So
My lord, 2nd May is the next date fixed in the before the learned trial judge. Now, my lord, they have already received a copy of the plaint and the injunction application. My lord, my humble submission is subject to your lordship's, my lord, kind sanction. My lord, let them file the objection, and my lord, let the injunction application be.
On merits, what is your challenge? Apart
on
from
the
that?
merits, my challenge is that they have been terminated way back in February 2024, and after nearly 1 year, more
At
than
the ad interim stage, the court has to proceed on the basis of
Your lordship, I should be very candid enough. I was not aware of the
section 92.
Yes. May I come back tomorrow?
Tomorrow, my lord.
Because the suit is fixed on Friday, your lordship.
We're not passing any orders, so you can proceed with the suit. We'll just say that affidavit of service filed today be kept on record on the prayer of the learned advocate for the appellant. The matter is adjourned for the day. Mr. Rai, please keep this with you. Hand it over on the next day.
May I get a copy, Your Lordship? Because this is
Ask-
not available. Sir, একটা copy পাবো?
No, Thursday we take up appeal hearing matters. This won't be touched. And Friday is the next date. That is a difficulty. Let us keep it on. Let us keep it tomorrow. Let us see if you are in difficulty. We cannot fix any time. Let it be in the list. If you are in difficulty, then we will consider.
Great. That a copy there?
Yeah,
Grateful. I'm grateful.
Can it be taken up tomorrow?
On the prayer of the appellant, let the matter stand adjourned for the day.
My lord, I'm for the appellant. I'm only praying for not today.
What is your name, please?
My lord, Shopal Chatterjee.
Shopal Chatterjee. On the prayer of the appellant, let the matter stand adjourned for the day.
I'm grateful, Your Lordship.
Thank you. 36, yes.
I am appearing for the performer respondent 10 to 14.
Yes. You are appealing for the
Well, 10 to 14.
respondent. Order 40 on stage.
Yes, Mala.
Order 40 on stage. We cannot give a right of hearing to you. None appears for the appellants at the time of call, although the respondent numbers 10 to 13.
10 to 14.
10 to 14 are represented through counsel. Let the matter stand adjourned for the day.
My lord, I'm for the appellant, my lord.
Is there a caveat, Mr. Shah?
No, my lord.
Very. Yes.
My lord, the crux of this matter is, my lord, challenging the surface action, the plaintiff filed one plaint.
Challenging surface
action instituted a suit for which, my lord, we being the bank, defendant therein, we filed an application for under maintainability. That application was allowed by the learned trial court. Against that, the plaintiff filed one appeal, not revision, appeal. And that in that appeal, the order of the learned trial court was set aside, and the suit was learned trial court was directed to proceed with the suit. Against that, my lord, this appeal has been preferred.
Is the appellate court judgment?
My lord, against the appellate court judgment.
No, you sought for a rejection of the plaint or order?
I have sought for the rejection of the plaint.
Rejection of plaint application was rejected.
Allowed.
Plaint was rejected.
Plaint was rejected by the learned trial court.
Obviously, the revision was not maintainable at all. No, they preferred an appeal.
Preferred an appeal.
Rightly, yes, that's appealable.
Appealable. That appeal was allowed in favor of the plaintiff, and trial court was directed to proceed with the suit. Against that, I prefer this appeal, my lord.
So then, why do you classify it as a misappeal? A regular appeal.
Regular.
Because
recently I've come across a judgment of the larger bench, my lord, also.
Which says it's a misappeal.
No. Had it been a case of revision, then this appeal would not have been. I would have rather would have required to come up under.
But Mr.
File one application under 227, my lord.
What has been done by the appellate court is it has set aside the rejection of plaint, right?
Rejection of plaint.
So that itself is not an order rejecting the plaint. The appellate court order is not an order rejecting a plaint.
My lord. No.
What is the, I mean, now we are in doubt whether it should be revisable or
My
second.
lord, I have this judgment of the larger bench. My lord is having. Perhaps this reference was done. I do not know. My lord. Perhaps.
Then.
My lord, I am having only one copy. My lord, I'm just. I আরেকটা কপি আছে না দেখুন থাকা তো উচিত ছিল তুমি তোমরা ছিল তোমরা ছিল দেখে নাও এখানে ডাউনলোড করে এটা আমি দর্শক এটা দিয়ে দেবো reference হচ্ছে whether the remedy lies by filing a second appeal if the divisional court reverses the order of the trial court refusing to reject the claim. As a corollary, if it is rejected, division degree given there is a difference. Division থেকে second appeal হবে না তো হবে না সেটা কি ডিসকাস করব trial court থেকে appeal
227, it has been held 227 legs.
My lord,
here it has been said Justice Chandra differs.
Justice Chandra differs, my lord.
Majority is 227.
My lord. My lord, kindly see is
let us just think it over once. Even 227 wouldn't be applicable. It would be a section 115.
115.
Because this is a typical situation where it was passed in your favor, it would have finally decided the proceeding. 711, if it was allowed,
my lord,
that would be the rejection of the plaintiff. The suit ends for all practical purposes.
Yes.
So this is a typical section 115 scenario. Because section 2 says that a decree, an order whereby a plaintiff is rejected is appealable, is a decree, right? Now, that was the trial court's decree. That was challenged in appeal. Up to appeal, it's all right. The appellate court says that the 711 is rejected.
711 is rejected.
Order 7 Rule 11, it is not, it cannot be called a merger because the issues in the suit are not decided finally.
No.
We agree with this.
My lord,
this bench. No, although not 227, 115 would apply.
My lord, may I read out this for my satisfaction? Page 32, my lord, page paragraph
of this judgment.
Paragraph 68.
Yes, absolutely.
Under such circumstances, we answer the reference in the negative in view of paragraph 32 of the Frost International Limited. The proper remedy would be to file a writ petition under 227 of the Constitution of India. We record, my lord, and the ordering portion of Justice Sinha, my lord, may I read out?
Where is that?
Page 34, paragraph 4 and 5, my lord, basically. Though the issue as to whether a second
appeal also says 227
lie from an, but here, my lord, this is lie from an order allowing application under 7 Rule 11 CPC by a court exercising revisional jurisdiction. Here, the court below was not exercising its revisional jurisdiction, my lord.
Justice Sinha says, though the issue as to whether a second appeal would lie from an order allowing application under 711 was not directly decided or even argued before Supreme Court, she was referring to that case. But the court, while deciding the issue as to whether the revisional court could have passed order to reject the plaint, held that rejection of a plaint is undoubtedly a degree, yes. Mr. Shaha, whichever forum rejects the plaint, it becomes a decree. Whichever forum. Even if a revisional court, if it was reversed, 711 was rejected and it was a revision preferred, if the revisional court rejected the plaint,
That
it would
becomes
be
a
a decree.
Decree.
And an appeal would lie against that.
Yes, my
Whether a first appeal or a second appeal, that is subject matter of debate, maybe. In our opinion, it would be a first appeal because that is the first court which decided. Second appeal lies only against a first appellate decree.
First appellate decree.
That is not a first appellate decree. That is for the first time the plaintiff is rejected by the revisional court. So first appeal would lie in that scenario. Here it's a reverse. Trial court rejected the plaint. It was a decree. Foolproof appeal. Appeal is preferred. What the appellate court does is that order is reversed. That decree is reversed. Therefore, the appellate court at the end of the day rejects the Order 7 Rule 11 application. Rejection of Order 7 Rule 11 application is not appealable nor a decree. It was a first appeal, but first appeal only because the color of the first appeal was derived from the nature of the rejection of the impugned order, trial court's order. So therefore, it's not a second appeal. Second appeal would be maintainable if first appeal passed a decree.
First appeal passed a decree.
First appeal did not pass a decree.
No, not a decree.
Could not have, because it rejected the 711 application. Therefore, 115 lies. We will hold that and dispose of your appeal and give you liberty to approach before the appropriate court. The present appeal has been preferred against a judgment and order whereby the first appellate court reversed the trial court's deemed decree whereby the learned trial judge had rejected the plaint in the suit. First up, the brief facts of the case are that the respondents filed a suit, according to the appellants, challenging measures taken under the SURFACE Act. First up, the defendants / present appellants. Now, defendant numbers 2, 3, and 4 / present appellants filed an application under Order 7 Rule 11 of the Code of Civil Procedure for rejection of the said plaint, which was allowed by the learned trial judge. First up, within the definition of under Section 2 of the Code of Civil Procedure, an order rejecting a plaint is deemed to be a decree. First up, as such, the judgment by which the learned trial judge rejected the plaint by allowing the appellant's application under Order 7 Rule 11 of the Code of Civil Procedure, was a deemed decree. Full stop. Thereafter, being aggrieved against the same, the plaintiff rightly preferred an appeal, treating the said decision of the learned trial judge to be a decree. Full stop. The appellate court, however, reversed the judgment of the trial judge and rejected the application under Order 7 Rule 11 of the Code filed by the present appellants. Full stop. Next para. The position, in order to elaborate the position of law, learned counsel appearing for the appellant cites an unreported three-judge bench judgment of this court in CO 3904 of 2017, where the majority decision was to the effect that under such circumstances, the remedy would lie by way of a division under Article 227 of the Constitution of India. Full stop. Next para. In the dissenting view, one of the learned single judges, however, held that an appeal would lie. Full stop. Next para. Upon a perusal of the said judgment and the law on the issue, we are of the clear opinion that a revisional application and not an appeal is maintainable against the present impugned judgment of the first appellate court. Full stop. Next para. This is not a clear case of merger, since no issue in the suit has been decided. Full stop. Under Section 100 read with order 42 of the Code of Civil Procedure, comma, a second appeal or a second appeal is maintainable only against a within double inverted decree passed by a first appellate court. Full stop, next para. To come within the definition of a decree, comma, however, comma, it is not sufficient that the judgment was passed in a regular first appeal. Full stop, merely because a judgment and a decision is passed in a first appeal does not transform the said judgment automatically to the status of a decree. Full stop, next para. In order to elaborate such proposition, comma, we could cite the instance of a remand order whereby the first appellate court remands a matter to the trial court, comma, in which case, although the judgment is passed in a regular first appeal, comma, the same is not a decree but an order of remand. Full stop, next para. In the present case, comma, although the trial court passed a decree by rejecting the plaint, comma, within the ambit of section 2 of the Code of Civil Procedure, comma, the learned first appellate judge, comma, while reversing such verdict, comma, did not pass a decree, comma, since the rejection of an application under Order 7, Rule 11 of the Code of Civil Procedure does not tantamount to either a decree or an appealable order within the four corners of the Code of Civil Procedure. Full stop, next para. Thus, comma, the impugned decision, comma, although passed in a first appeal, comma, was merely an order and not a decree. Full stop, as such, comma, there is no scope of any appeal, any second appeal being maintainable against the same. Full stop, next para. Even otherwise, comma, the present appeal has been categorized as a first miscellaneous appeal. Full stop, however, comma, since the order of the first appellate court, comma, rejecting an Order 7, Rule 11 application, comma, is not appellable either under Order 43 of the Code of Civil Procedure or under any other provision of law, comma, no appeal, comma, whether miscellaneous or regular, comma, is maintainable against the said order. Full stop, next para. Perusing the provisions of section 115 of the Code of Civil Procedure, comma, we find that this is a fit case where the rejection of the application of the appellants under Order 7, Rule 11 of the Code of Civil Procedure passes muster, passes MUSTR, master, as a double inverted with the case decided, which, comma, within the ambit of the explanation to section 115, comma, is a perfect example where the impugned order, comma, if the same was passed in favor of the present appellants, comma, would have finally decided the suit by rejection of the plaint. Full stop, next para. As such, comma, the present impugned order of the first appellate court is amenable to the to civil revisional jurisdiction under section 115 of the Code of Civil Procedure. Full stop, next para. As such, comma, we find that the present appeal is not maintainable, comma, since the impugned order of the first appellate court is not an appealable order at all. Full stop, accordingly, FMA 669 of 2025 is dismissed as not maintainable, comma, with liberty to the appellants to prefer a proper civil revisional application under section 115 of the Code of Civil Procedure before the appropriate bench taking up such matters. Full stop, next para. Consequentially, can 1 of 2024 is also dismissed. Full stop, we make it abundantly clear that we have not even touched the merits of the respective contentions of the parties, and it will be open to the appellants to take all points raised in the present appeal in the revisional application as and when filed. Full stop, next para. The leave is granted to the learned advocate on record for the appellants to take back the certified copy of the impugned judgment and order of the first appellate court, as well as the judgment and decree of the trial court, upon furnishing photocopies of the same, comma, for the purpose of preferring the revisional application. No address to costs. No, order. Maintainable না বলে করেছি তো order হবে।
Lord, the plaintiff, Lord, is the appellant before your lordship in a suit, Lord, for eviction on the ground of Lord, reasonable requirement under the 97 Act. Appeal is directed against an order of remand. On the last occasion, Lord, it came up before your lordship, Lord, directions to rectify the defects were passed. Lord, we have rectified those defects.
You'll admit the appeal. Like a first appeal.
Lord, there are two things.
You have checked up, you have rectified.
Yes, Lord, it has been it was rectified on that day, and the subsequent Lord deficit court fees and all those were also paid.
Yes, yes.
Previous
report is there. Yes.
Lord, there are 3 applications.
Achha, let us first admit the appeal. Since questions of both fact and law are involved in the present. Achha, one second. Mr. Kormakar, are you challenging any of the findings on merit? I mean, then it would be in the nature of a second appeal.
Yes, the only finding that is challenged before your lordship today is, Lord, that the court came to a finding, both the courts came to a concurrent finding that the landlord-tenant relationship is there, the notice is valid.
You are the plaintiff.
I'm the plaintiff. Now, Lord, the only differing point is, Lord, that the appellate court came to a finding that because there was no commission held, so, Lord, the space available in the suit premises could not be assessed. Now, Lord, I say that the sale deed of the suit premises was already on record exhibited. From the schedule of the suit premises, Lord, it's a self-contained flat. So, Lord, the number of rooms, hall, kitchen, everything was visible. There was no requirement to hold a Lord separate inspection. This is the only point, Lord, to be taken addressed in the appeal. Nothing more than that.
The present appeal arises out of an eviction suit filed by the plaintiff stroke appellant full stop. The said eviction suit, filed inter alia on the ground of reasonable requirement under the concerned provision of the West Bengal Premises Tenancy Act 1997, was decreed by the learned trial judge, full stop, the first appellate court, while reversing the findings and remanding the matter to the learned trial judge by the impugned judgment and order, observed that since no commission was held, the reasonable requirement was not established. Full stop. Learned counsel for the appellants argues that on the basis of the particulars as given in the sale deed of the appellants, sale deeds in favor of the plaintiff's appellants, which was marked as an exhibit in the suit, it would be amply clear that it would be amply clear as to what are the existing accommodations under occupation of the plaintiff stroke appellants. Full stop. Next para. As such, learned counsel for the appellants contends that the learned first appellate court ought to have decided the suit itself, decided the appeal itself within the contemplation of Order 41, Rule 24 of the Code of Civil Procedure, since the necessary evidence required to adjudicate the appeal are already on record. Full stop. This appeal is required to be heard on the above question as well as the other grounds taken in the memorandum of appeal. Full stop. Next para. Yes, what is the application?
For the first application, kindly takes up Can 2 first. So that's the application for leave to appeal, because the original plaintiff, Lord, had died, Lord, after the judgment was passed, but before preferring the appeal. Original plaintiff.
এই অর্ডারটা আগে হবে, অ্যাডমিশন অর্ডারটার আগে হবে, এটা যেটা এখন বলবো। Can 2 of 2024 is an application for leave to prefer the appeal by the present appellants, who are the heirs and legal representatives of the original plaintiff who died after
Original
the
plaintiff
passing
number
of
one.
the
Original plaintiff number 1.
original plaintiff number 1, comma, who died after the passing of the impugned decree of the first appellate court, impugned order of the first appellate court, but before the filing of the present appeal. Full stop. In view of the facts as made out in the application, comma, can 2 of 2024 is allowed, comma, thereby granting leave to the appellants to prefer the present appeal. No arrest to cost. তারপরে যেটা ওই বাকি অর্ডারটা করলাম সেটা আসবে পুরোটা। তারও পরে হবে। Yes, what is the
Lord, kindly takes up can 3.
application for assignment means?
Lord,
Some other bench.
In the meantime, Lord, the now, Lord, the appellant number 2 has Lord transferred his interest in favor of appellant number 1 during the pendency of this appeal. So, Lord, his name may be expunged, and Lord, appellant number 1 is already there.
2 has transferred to 1.
Appellant number 2 has transferred in favor of appellant number 1. His share.
Can 3 of 2025 seeks deletion of the name of appellant number 2, Sheikh Muhammad Shamim, on the ground that the appellant number 2 has in the meantime, comma, transferred his share in the suit property in favor of appellant number 1. Full stop, next para. But we'll keep the question of non-joiner open for them to be taken on this ground.
Lord, I was the plaintiff, Lord, non-joiner, Lord, by way of gift or deed of gift.
Non-joiner in the appeal,
Achha.
because they may challenge subsequently this. We'll make it clear in the order. Next para, we find from the annexures to the present present application that sufficient that a deed of gift within bracket hiba dated September 27, 2022, but in bracket it's written 24.
24. It will be 24 because registration is in 24. Lord, unfortunately, the typographical error.
2024 has been annexed whereby such transfer took place. Full stop, next para. Accordingly, can 3 of 2025 is allowed, comma, thereby deleting the name of the appellant number 2. Number 2, at the risk of the appellants. We'll just say that. At the risk of the appellants. Full stop. Next para, the learned advocate record for the appellant shall carry out the necessary corrections to delete the name of the appellant number 2 in the memorandum of appeal and the other pending application bearing can 1 of 2023 during the course of the day. Do that.
Lord, can 1 is Lord for
stay of what?
Stay, Lord. Lord,
Achha, stay of all for the stay of operation. Remand to stay na korle hoye cholbe.
Basically, all further proceedings of the ejectment
Yes,
suit, Lord, has
we mold the reliefs as sought in the present application and grant stay of all further proceedings in
No, ejectment suit number 530, just Lord at the bottom of the first page.
In ejectment suit number 530 of 2011, pending before the learned judge, comma, 5th bench, comma, Presidency Small Causes Court at Calcutta, after remand till disposal of the application. Full stop. The appellants shall serve a copy of the application bearing can 1 of 2023 on the respondents to opposite party, indicating that the application shall be listed under the heading application on May 19, 2025, when an affidavit of service shall be filed by the applicant. Achha, you have mentioned their SAT number.
Lord, that was corrected, Lord. Pursuant to Lordship's direction, it was classified as Lord FMAT.
Achha, we grant further leave to the learned advocate for the appellant to rectify the cause title of the of can 1 of 2023 by incorporating the proper number of the present appeal. because in this ACT number
Yes,
still is
Lord,
different.
the
At
problem
that
is
point
not
of time,
the
that was the
ACT,
number.
not no, not the FMET
So
number.
correct that
Yes,
number.
yes,
We have
here
taken
and now.
it. Here and now correct and then serve. Great. Solve the corrected copy. Great. Thank you. Both judges' copies and as well as your copy which you will send.
আগের দিন যেরকম দেখিয়েছি
Great. হয়ে গেল অর্ডার পাঠাতে পাঠাটা এখন যদি কেউ থাকে করবো তাহলে হিয়ারিং তো একটা ধরলে চলবে Yes.
39 and 40, Your Lordship, I am appearing on behalf of the respondent. On the last occasion, the appellant has concluded their.
Yes, you are to argue now.
Your
Yes.
Lordship, unfortunately, the brief has not come today.
Oh. On the prayer of the respondent, the matter is adjourned.
Apart from that, one more prayer, Your Lordship. Mr. Bhattacharya is leading me in this matter. If Your Lordship can kindly fix it any day next week, Your Lordship.
Mr. Shono Bhattacharya? Why?
Your Lordship, there's some other matters he need to go through, or which he need to go through this.
What matters we won't grant you time. If you can find time, let him come tomorrow if you take up tomorrow or day after tomorrow. On the prayer of the respondents, the matter is adjourned for the day. Really for the day. Sir.
My lord, not today. The other side.
Appellant.
Yes. Appellant in item number 41 and opposite party in item number 42. Cross appeal.
My lord.
You are for the other side.
Kindly not.
On the prayer of learned counsel for the parties, let the matter stand adjourned for the day.
Deeply okay.
But give your names all the same for that adjournment prayer. Somebody's name has to be given. Whoever you have a disliking of, you can give it. Anyone close to Mr. Basu, you can give his name. ডাকুন মিস্টার সরকার করবেন ইয়েস Yes,
Lordship. Well, it takes up tomorrow. Mr.
You
Chair-
too, Mr. Brutus.
No, difficulty there is a resolution, but so they could not.
On the prayer of learned senior counsel, on the prayer of learned counsel for the parties, let the matter stand adjourned for the day. নাম বলে রাখো। Please give the names, whatever, the junior's name at least. সব পাঠান কাজে রেজলিউশন আছে হঠাৎ রেজলিউশন নিলে আমরা তো জানতামই না আমাদের কিন্তু ফর্মালি কমিউনিকেট করে নিতে হবে But Mr. Banerjee, the resolution has not been formally communicated to us.
Not even one line.
No circulation from the chief because it happened probably after that. When we came to court, till then we checked our phone, not for this, but we did not find any such communication. And nobody, not a single portfolio holder of the bar has come to the court and mentioned. We are telling you that. So we are not, it's not an ego thing, but you should at least, because people who don't know, they will be taking exception. And some courts do take exceptions. While at the bar, I saw many courts take exceptions.
The committee must communicate.
Somebody from the committee, anybody from the committee, official communication has to be there. Next. Not in our code now, because we know now, but you should communicate before the other. Not today, both sides, if both sides are not there, will not do anything. One order record, not today. Or agada order, is not today order.
And this
সই করতে হতো
এদের পরে তো প্রেসার 55 7 to
Yes, Mr. Dutta, you want to do the matter, then we'll take up.
The other side is not here. Mr.
Not today, করে দিন কোন order.
This matter, my lord, will not take much time, my lord. This matter, my lord. What happened, my lord? This matter, my lord, the trial court.
If you want to do. Otherwise, we'll just make it not.
Others in the absence of others, my lord.
Not today then. Not today, same.
Agree.
Same. They can have this, they are delegation. উৎপল কোথায়?
61. Lordship, since it's 50, I'm for the appellant. I'm also praying for not to.
Nothing.
By 66, 67.
Or at any matter where there is urgency or both sides are present or want to do the matter, then we are rising.